Hey, all persons having anything to do before the Honorable Justice of the Appeals Court, now sitting in Boston, far and within the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases that we'll be hearing this morning, to my right and your left is Justice Kenneth Desmond. To my left and your right is Justice Rachel Hirschfang. The first 3 matters on the list for hearing are all criminal matters. We will take a brief recess after hearing the 3rd case before we resume the session with the 3 civil matters at 4, 5, and 6. We are familiar with the procedural history, the factual background in each of these cases. You needn't recite that for us. We will have questions for you. Each side of the V has 15 minutes to argue. If there's more than one attorney arguing on either side of the V, please let us know ahead of time how you'll be dividing your time. And as I think you know, there is no rebuttal. The clock on the podium, as you are probably familiar, has a digital readout that begins at 15 minutes and goes backwards until it reaches 0. When it reaches a minute and a half, the light turns from green to yellow. That's a good sign to begin wrapping up your presentation. When it reaches the end, the light turns unmistakably red and flashes. That's when your argument comes to conclusion, unless we have further questions for you. And if you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. If you reach the end of your argument before you reach the end of your time, there's no obligation to continue speaking to us. With that, I will call the first case, case number 23, P131, Commonwealth versus Joel Monegro.
Good morning, Your Honors. Tara Ganguly for Mr. Joel Monegro. I have 3 issues to present to the court this morning. I'd like to actually start with the second issue that I raised in my brief, which is the prosecutor's closing argument in this case, because I think it sort of encapsulates the problems in the other issues. The prosecutor stated, "It is inconvenient to whatever that was on the stand Friday afternoon," referring to the defendant's testimony, "and this morning. A, quote, demented jigsaw puzzle put together with half-truths and out-and-out lies." The court is certainly familiar with the prosecutor's ability to argue from the evidence, but not the ability to put his or her own personal beliefs about a witness, and in this case, the defendant, before the jury during closing argument.
Did the prosecutor begin with, "I suggest to you"?
I don't believe in that specific sentence that I'm talking about, no.
What is the distinction between arguing from the facts or the evidence why the defense theory ought not to be believed, and the prosecutor imposing their personal views as opposed to the reasons why, in their view, the evidence doesn't support the alternative version?
I think the prosecutor could have, cherry-picked from the evidence. There was a significant amount of evidence that both the Commonwealth certainly put in a significant amount of evidence.
Right, but ultimately they are simply then taking those reasons and then drawing a conclusion, obviously expressed in this instance in colorful phrasing. But I always understood the vouching, or the prosecutor's introduction of their personal belief, to rely or imply reliance on special knowledge that they held outside the confines of the trial evidence. Isn't that the distinction that we're looking for?
Traditional vouching has been, you should believe the victim, or you should believe this witness because XYZ. This is not necessarily vouching.
No, but because XYZ, where XYZ is not something that is in the trial evidence, right? Because if I'm a prosecutor or a defense attorney, but if I'm a prosecutor for these purposes, arguing from the evidence, I can say you should believe the evidence because her testimony was corroborated by X, by Y, by Z that you all heard. What I can't say is that you should believe this witness because I know her to be of strong moral character, right? That's vouching.
Yes. But I think the opposite to vouching happened in this case, where the prosecutor just basically called the defendant an out-and-out liar, which she may believe, and she certainly wanted the jury to believe that he was an out-and-out liar.
Based on the evidence, based on the reasons why the story didn't hang together, based on what the jury had heard, at least as the prosecutor was arguing.
Well, it hung together to some extent because the prosecutor was certainly pushing for first-degree murder, and they didn't come back with.
But what's improper is where the prosecutor attempts to cause the jury to rely on the prosecutor's say-so, standing independently and based on something outside of the confines of the evidence, I haven't heard you yet describe what the prosecutor asked the jury to rely on here outside of the evidence.
With respect to what I am raising as problematic, this statement, demented jigsaw puzzle, out-and-out lies, I don't think that the prosecutor pointed to any specific evidence, meaning didn't point to, the defendant testified that, Torres stabbed him first. She didn't pull in his actual testimony, she just called him demented. And I don't think that is
Maybe
allowed.
not in that particular point, but elsewhere in the closing pointed to the inconsistencies and the reasons why the testimony ought not to be believed.
Certainly.
Okay, so they don't need to, with each statement, tie it to the evidence. They can inventory each of the reasons why the testimony is questionable, should be viewed with skepticism, should be disbelieved. Having done that, so long as they are not introducing extraneous material, drawing the ultimate conclusion that this is a wild tale that doesn't deserve credit is fair game, as I understand it.
There are cases that I've cited, and some perhaps that I failed to cite, that talk about mocking the entire defense. A prosecutor is not allowed to mock the entire defense.
It's a different issue, and that's when the characterization and colorful rhetoric, as I described it before, simply goes too far.
I think this went too far. I think calling the defendant a demented jigsaw puzzle went too far. That's my opinion. The court can.
So I don't know that she called the defendant that, but in any event, is it the word liar? Is that what you should take issue with? If she had said falsehoods, would that have?
I think demented jigsaw puzzle was the phrase that really jumped out to me when I was reading it.
And she was addressing ambiguities that were supposed to have been highlighted in the defense attorney's opening and somewhat less in his closing. Is that correct?
Yes, she was highlighting ambiguities, and then she I remember that from above where I'm talking about in the transcript. Moving on, if there are no further questions about that issue. The dying declaration, there were only two people here that truly know what happened. Unfortunately, only one of them was left to tell what happened, and the Commonwealth, granted, had to.
The other one died.
Yes.
Shortly after making that statement.
Yes. The Commonwealth was forced to present its case and its evidence in a way that, from its perspective, showed that my client was the aggressor. My client testified that she was the initial aggressor. The jury was certainly able and tasked with figuring out who was the initial aggressor. And by admitting the statement, when the EMS tech asked her what happened, and she says, he stabbed me. Yes, he certainly stabbed her. We know that. He says that she stabbed him first, that she attacked him first.
So I'm having, there's a leap that you're making that I can't quite follow, and I'm hoping you can help me. I hear you to be saying that the statement, he stabbed me, which is all she said, must be read to mean he stabbed me first. And I don't know why that is a required reading. Can you help me?
I mean, I suppose she could have said as she's laying there bleeding out, we got to the response to the question, what happened? We're breaking up, we're divorcing, he's moving out, we got in a fight,
She's bleeding out. I mean, I understand that she could have said more, but the thing that was top of mind at the moment was the source of her injury.
Yes.
And so she says, and, having watched the video, it's clear that she had very little capacity at that time to say anything. So the words she says are those 3 words, he stabbed me. On the evidence as a whole, I think that's uncontroverted. I mean, he admits that he stabbed her. So the part that and I understand how important it was both to the Commonwealth's prosecution of its chosen theory of the case and to your your client's defense to establish that he did not start it, or at least didn't bring the knife into it. But I'm not able to connect the 3 words, he stabbed me, to a notion that must have meant to the jury that he was the first stabber.
I can certainly see your, not confusion, but your thought versus my thought, but I think that's more toward, I mean, if the court was to find error, I think that goes more towards prejudice.
Doesn't that matter? Don't you have to win both?
Yes, of course, of
What
course.
exactly is the error? That she was allowed to say, he stabbed me?
Yes, so the judge has to find by a preponderance of the evidence initially that there was sufficient evidence that she was aware of her own imminent death.
Okay, and so
she's...
reason to suggest that. He tells the EMTs when they're coming, we're dying. He had called the 911 and indicated we're dying.
Right.
And I think reasonable jurors could infer that she was able to hear those representations when they were being made.
I think that was certainly a discussion between the parties about whether reasonable jurors... We don't know exactly where he was when he made that phone call in the apartment and whether she could actually hear him. She's laying, dying on the floor.
Both of them were laying next to each other, according to the video that I saw. The one
When they arrived.
And when the police arrived.
Where they were when the EMTs came in, right?
Yes. Before that, from his testimony, he at least called Dodge first and then called the police. So I'm not sure if he was laying right next to her when he made those calls. But even if she did hear him saying on the phone, help us, we're dying, I understand this may be a leap, but it is my argument. He didn't die. So
her reliance on he was wrong about his own mortality.
Well, he was.
And in any event, it would be up to her subjective assessment of how much weight to place on his statement, even if she heard it. What she was aware of, however, was her own rapidly deteriorating condition that ultimately did result in her death. She had fatal stab wounds.
Yes, she had a fatal stab wound, a serious...
And she was asked by the arriving medical professionals what happened, and all she was able to get out were the 3 words, he stabbed me.
She also I don't know if the court technically admitted this as a dying declaration, but she kind of moved her head, and there was testimony that she kind of shifted her head and nodded at him.
Right.
I don't know if that's...
Okay, well...
So, but I would just point to
our standard of review on the judge's decision to allow this testimony is
abuse of discretion.
Abuse of discretion. And so what you're asking us in these circumstances is to conclude that the judge abused discretion in concluding that the deceased witness, was aware of her impending mortality at the time that she gave those 3 words to the arriving medical professionals.
Yes, I think it can be...
At the same time as the guy who wound up surviving expressed his view that both of them were dying.
When you look at the cases that talk about what kind of injuries a victim had, and it's not, you must have this type of injury, certainly, but Commonwealth versus Moses, the victim had been shot 4 times, 2 in the chest. Commonwealth versus Nemec, the victim had been stabbed in the heart. Commonwealth versus Middlemiss, the victim had been shot 5 times. I understand, obviously she died. She was mortally wounded. She had a serious stab wound to her left bicep with probably an arterial bleed and some other stab wounds.
She's losing
Other stab
consciousness.
wounds, were they 30 other stab wounds? When you say other stab wounds, she had one to the bicep, but she had like 30 other stab wounds and slashes, right?
Unfortunately, I don't remember the specific testimony of the medical examiner. She certainly had other significant other stab wounds.
Want to talk about your crime scene photos argument?
Yes, Your Honor. Moving into that, there were the 2 autopsy photos, and there were 32 photos of the apartment. The Commonwealth's theory was that they moved around in the Commonwealth is essentially trying to say they started here, he stabbed her here, she moved here, he followed her, based on these blood pattern. I don't think it was great evidence. I mean, it was certainly admissible, but it wasn't overly convincing evidence based on still photographs that this is how the interaction moved around the apartment. There were so many photos, and the court admitted, at some point, the court said multiple times, this is going to get to a point where it is overly prejudicial. Multiple times the parties talked about this with the court, and yet every time the Commonwealth introduced a photo, which were all objected to, the court admitted it. So the court basically did whatever the Commonwealth wanted, but knowing in the back of his mind that, yes, this could be a problem.
There were additional photos that were not offered and admitted, is that right?
Yes, Your Honor.
And so I hear you on the frustration of a judge who seems to be thinking the right way, but from your client's perspective, ruling the wrong way. But isn't it also, first of all, that's obviously not the standard of review, and I know you're not arguing that. But isn't it also possible that in his mind, he thought, well, if we get to 100 photos or if we get to 70 photos, that's going to be prejudicial, and it never got there?
Certainly. I mean, I suppose he could have had a number in mind, but depending on the photos themselves, which, the court has in the record appendix, it was just a lot of blood. It was a lot of blood for, he almost died too, and we don't know how much of that blood was his versus hers. So
that was part of his defense, right? That it was actually defensive on his part, and so the fact that he was also bleeding heavily and seriously injured actually worked to the defendant's advantage with respect to the argument to the jury.
Well, but he didn't want the photos in to begin with.
Didn't the judge try to, were any of the pictures duplicative of one another? Didn't he try to say, okay, there are a lot of pictures, so I'm not going to allow any of these photos in twice, but if you want to capture where the blood was in the various parts of the home, as long as they're not duplicative, he allowed many of them in, isn't it?
Well, certainly not the same exact photo, like the same print, but when you scan through the 32 photos, they are very similar.
I think it was 42, I think.
Yes, thank you, Your Honor.
Thank you. For the Commonwealth?
Good morning, may it please the court. Catherine Jansen on behalf of the Commonwealth. I'll first start with the closing argument issue. I would suggest that this was not vouching. It was not the prosecutor expressing a personal belief. Belief. It was grounded in the evidence, which he then dissected over a course of a number of transcript pages.
Was it inflammatory or inappropriately or excessively disparaging, if not vouching?
Well, I think it was definitely colorful language and enthusiastic rhetoric, and perhaps better left unsaid in that manner.
So what do we do? I mean, we have these conversations all the time, and yet the cases keep coming back with things that were better left unsaid.
From experienced prosecutors. I mean, this is a murder trial. This is not somebody in district court just getting their trial legs under them.
Understood, Your Honor, and I definitely understand where the court is coming from, and this is obviously relayed back to the office. I'm sorry?
Do you talk to each other about this?
Yes, we do.
You do?
We do, and we have conversations about this within the office. I can report that to the court. And I think in this case, the fact that if the court finds that this was inappropriate for that reason, not because it was vouching, I would suggest the verdict establishes that the jury weren't overborne by this argument, and the fact that not only was there the general instruction that closings aren't evidence, but there was a specific instruction as well by the judge that if you should not be swayed by emotion, and there's a specific instruction about any personal beliefs or opinions expressed by the attorneys are not evidence and should be disregarded, and that's at transcript page volume 6, 185. So I understand the court's frustration and valid concerns. However, in this case, it does not warrant reversal.
I haven't been doing this as long as my retired friend and colleague, Justice Brown, who, as you know, had a special place in his imagination for these kinds of concerns. But I have been having this conversation for more than 22 years. And as I confront my impending departure, it's a little frustrating and disappointing to realize that how little progress we've made.
Understood, Your Honor. I will again relay the concerns of the court and have discussions with the prosecutors.
The question is, how much should we do? How can we help? Send that message.
I think a strong decision about that this type of language is inappropriate and improper. I don't think reversing a conviction on this, especially on the facts of this case, would be appropriate, though, especially because of the verdict that came back with the jurors. It shows that they were not overly swayed by this, and that I don't think is a just sanction in this case.
The defendant testified in this case?
He did.
Did he tell varying accounts as to what took place?
He did.
Is that what the government was talking about in this closing argument?
Correct. She was commenting on his testimony and his varying accounts and why his accounts essentially were a jigsaw puzzle that didn't fit. That was the gist of it. It was enthusiastic and colorful language. And
The jigsaw puzzle doesn't fit is fair game, right?
Correct. The word demented probably should not have been included.
Demented is a little bit excessive and unnecessary.
And out and out lies. I mean, you know, whether it be, I don't know, parsing words too closely or not, the law does draw a distinction between the use of the word lies and liar and the use of other words that can be understood to demonstrate a disbelief. So that should just be out of everyone's lexicon.
Understood, Your Honor, and that will be
What about the
relayed.
dying declaration?
Yes. I think there was no abuse of discretion from Judge Drescher on this point. Not only did the 911 call actually come in which you can hear the victim moaning and talking, him calling her name, saying, we're dying here. And the first responder video also shows that he's, and I believe you can hear it in the 911 call as well, that he's still on the phone as the first responders are coming in. So you know that I think there's a fair inference that she can hear this. And defense attorney did concede that the 911 call comes in, that the foundation probably would be met. But apart from that, I think the character of the injuries alone would have been sufficient to show that she had an imminent belief of death. The first responder said the wound to her bicep was so deep it was down to the bone. He believed it was an arterial bleed. And there was also a stab wound to her neck that was very deep, as well as a wound to her spleen. And the fact that she's weak and essentially bleeding out, I think, would be a fair assessment. I think NIMIC is probably the case closest based on the facts, where there's no evidence also of a medical first responder saying, I think you're dying. I thought the other cases have that type of conversation, but there was a stab wound to the heart and basically bleeding profusely, breathing heavily, and kind of having trouble focusing. And I think you have all of those factors here. So I think the judge was well within his discretion. If the court would like me to address the graphic photos, I'd be happy to. Otherwise, I'd be happy to rest on my brief.
I just have a question about another piece of evidence, and when Attorney Ganguly was arguing, it seemed like it might be relevant, but I'm not 100% sure I get it. So the still photos from the video where he comes to the back door and he's covered in blood. Should we consider those in light of your sister's argument that we don't know where, or that would the jury have been asked to consider them in light of the argument that we don't know exactly where the defendant was when he made the calls, because he's quite clearly bloody, and he's walking to the back door and looking out it for whatever reason I don't know, but he was mobile.
Right, and I think you can see him holding a phone to his ear. I think that was argued by the prosecutor. I mean, I think you can consider that, but I think it's a preponderance of the evidence, so it's a lower burden or lower standard. And there was evidence that she was clearly within hearing distance, I think, where you can hear her moaning and talking. And I think Dodge said, please put her on the phone, and he put her on the phone and she was moaning, and he had said, we're dying here. So that alone, even like with the 911 calls, if there's a question about it, but I think also where he is next to her when they come in, it's on the video and the phone's at his head, and I believe you can hear it in the 911 call as well, the first responders coming in. So I think there's more than a fair inference, but I think the jury could consider that, but it doesn't mean he was. And I think when you look at the crime scene photos, you can kind of see the door that he had gone out, I believe, and that was close to the dining room where she was. I'm happy to answer any other questions the court may have.
Seeing none, thank you both.
Thank you.
The next case on our list for hearing is case number 2023 P518, the Commonwealth versus Rodney Ferguson.
Good morning. Philip Weber representing Mr. Rodney Ferguson. Mr. Ferguson's case is here today for 3 issues. I'll begin regarding the search warrant issue, as the search in this case should have been suppressed. The search in this case, search warrant I should say, was based in large part upon information from a confidential informant. However, this confidential informant did not satisfy either the veracity test or the basis of knowledge test. The veracity test was based off of what I could say is probably the most generic statement possible in regards to the police saying that they had worked with this confidential informant in the past. No information in regards to how recently they'd worked with him, how many times they'd worked with him, the results of having worked with him. Now, I understand that with a confidential informant, there is some levels that have to be taken in regards to protecting their confidentiality, but there needs to be some limits in regards to this. Otherwise, a statement such as this, the idea of, well, it's someone we know and have worked with, and that's about it. I mean, there's no way to...
Isn't there some direct corroboration drawn from the controlled buys?
In regards to the controlled buys and which I was planning to certainly address, is the separate issue.
Typically, when we get these cases, the challenge to the search warrant is not on the Aguilar Spinelli for the CI, when the CI has participated in the controlled buys, because the buys themselves corroborate the account of the CI. Typically, the question is nexus.
And in this one...
And in this case, we have not just one, but 2 controlled buys, but one of the controlled buys took place in the house 48 hours before the execution of the warrant.
And understanding that, Your Honor, however, I would still argue that the controlled buys there was a problem with the controlled buys as well in this case. And one of the controlled buys, I point to the other issues in regards to the veracity and basis. It is certainly factors, at least in regards to the search warrant. When it comes to the controlled buys, I think one of the biggest problems here is the involvement of this middleman, which was given the name of John, which I believe was used as a pseudonym. Now, John, the middleman here, was certainly not a knowing participant. He was not working directly with the police, at least not knowingly. And this person, John, was actually described as confidential informant as a drug dealer himself. So John is the person who is basically arranging everything. Now, John's involvement, I would say, makes problematic because anytime there are controlled buys, the procedure that the police use is very important. Part of that procedure, of course, being the idea that they check the confidential informant before the controlled buys, making sure they don't have any drugs, any money, anything that would taint, basically, the controlled buy.
Just to cut to the chase, your suggestion, if I understand it correctly, is just the question of what we can know with certainty, and more specifically, being unable from the activities of the police with the CI to exclude the possibility that John, not the defendant, was the source of the drugs in the controlled buys?
I mean, yes, Your Honor, because I say that development of John, I mean, it's almost akin to if the police had performed a controlled buy with a confidential informant, but didn't bother to check him beforehand, didn't bother to search him beforehand. Because that is essentially almost the equivalent of what we're dealing with. Actually, I would say even worse, since at least with a confidential informant, there's an idea, supposedly, that there's a level of trust here with John. Obviously, we don't have that level of trust, so.
But, I mean, they go to, first of all, this is not a case where the confidential informant is said to have given the money to John, who then went to the defendant to buy the drugs and then came back and gave the drugs to the CI, right? They go together. So we do need to take into account that the defendant and, that John is an intermediary, but he's not a solo, doing part of it without the CI intermediary. And then at least one of the transactions took place in the defendant's home. So the PC to search goes to the home, even if, for example, and I don't know why this would happen, but things happen that I don't understand all the time, even if the defendant were allowing his friend to deal drugs out of the defendant's home, which seems unlikely given the dangers, but who knows, that it would still establish that there would be probable cause to believe that there might be crimes being committed in that home, right?
Well, if there's the idea that one of the problems is, well, one thing I would note, Your Honor's comment of who knows, I think, is problematic because that does lead us to a level of uncertainty. But even beyond that, we don't actually know exactly what happened inside the home because this is not a scenario where the police were able to observe anything inside the home. They know that these 3 people enter the home. We don't know exactly what does take place.
That goes back to veracity, right? Because we've got the CI's account of what took place. And we know that that he went to the home for the purpose of completing a buy. He completed the buy and returned with the drugs. So we've got probable cause to believe that drugs would be found in the place where he had purchased them on at least one occasion, controlled by the police, from whom it doesn't really matter, for as Justice Hirschfang observes, for the probable cause to search the home. And while the uncertainty that you've introduced by the presence of the intermediary could go to the question of who sold the drugs to him, that's a question for trial. And as I understand things, the circumstances of that particular sale did not come into evidence.
Well, in regards to, Your Honor did just say one thing I think that is important, that said it goes back to the veracity. And as I stated, there is a problem with the veracity of this confidential informant, because this veracity of the confidential informant is, again, based off of probably the most generic statement of, well, we know this guy the police statement of, essentially, well, we know a guy, we've worked with him in the past. It's not exactly so
we know a guy who we've worked with in the past that has led to many arrests and arrests for guns and drugs and a number of assorted things. Right? So it's not just we know a guy who says he knows drug people. It's a guy who they've worked with in the past that have led to, I forget what the number was, but I think there was a number in there, many arrests and for drugs and possession. So it's a little bit more than that. There was the drug deal that took place in the house, but they also observed the defendant leave the home for the second drug deal, right? They were sitting on the house, and they watched him actually leave the house right before or right after the drug deal had been arranged and go and make this exchange, correct? So there's that, and that one of them happened within 48 hours. I forget which one it was. Do you recall? Was it the one in the house or the one where he left the house that happened within 48 hours of the search? Do you recall?
Well, one note I would like to make, Your Honor.
Which one was the one that he left the house within 48 hours or the drug deal that occurred in the house?
It was the house.
In the house.
Yeah.
And I would like to make note, though, Your Honor stated that in regards to the veracity element of it, the police never actually did state how many times that they had worked with him in the past. And I did even note that as finding that to be an issue, not having a specific number in regards to that. But even in regards to this...
Pointed to, they didn't see actually what happened when in the house when the exchange was made.
That's correct, Your Honor.
Is that uncommon?
I mean, it depends on the different scenarios. I mean, plenty of search warrants do involve direct observations of what happens. If it's inside a house, it doesn't always, but I would say that is.
The strongest, it's kind of a catch-22, because the strongest indicator in support of a search of a dwelling is a sale that takes place inside the dwelling itself. But inherent in that kind of a situation you're not going to have the direct observation of the hand-to-hand exchange. You're going to be relying on the CI who's participating in the controlled buy.
But if we were involving a CI, then that would go to the fact that, and this isn't to say that every single scenario is the exact same. Obviously, we're dealing with this specific case, and in this specific case, the fact that we don't have we have issues with basis of knowledge.
Yeah, but this specific case shares common elements with a number of others that have passed muster.
I had yet to find a case that had the exact same scenario in regards to it.
But quite often, Aguilar Spinelli is satisfied by the participation of the CI in controlled buys.
In general, controlled buys, yes.
And also, as Justice Desmond observes, the reliance on the CI for successful prosecutions in the past.
Well, we actually don't know if they were successful prosecutions, as there's no indication, because even if you're referring to an arrest obviously does not indicate necessarily a successful prosecution. All that would indicate is, well, an arrest, and obviously an arrest has a much lower threshold than it would be for a successful prosecution.
I think that I'm just reading from the affidavit, but it says these investigations have also resulted in convictions of drugs. Is that not based on CI? Or that was just the officer's experience?
Well, and I apologize if I don't have the exact wording in regards to the words from the search warrant. I just recall that the search warrant, in terms of veracity, was a fairly generic statement, that really so generic that it makes it almost impossible for the defendant to have been able to try to challenge any specifics in regards to it. And I find that to be incredibly problematic in how broad and general some of these statements are. And even in regards to the one transaction that allegedly took place inside the home, I mean, that would establish, again, because of the two of them, we only have one inside the home, that would establish at most that someone, because again, we don't know if it's John or otherwise, might have had one controlled buy. And I would say that in most cases and situations where there's a singular controlled buy with nothing else, certainly does create some doubt in regards to whether there would be sufficient information to justify a search in regards to it. Moving forward, unless there are any specific questions, moving forward into the next issue, the motion for mistrial should have been granted in this case in regards to the officer testifying multiple times inappropriately throughout the trial. Now, there's certainly no question that the testimony was inappropriate. It was objected to, sustained, and instructions given that was strict for the record. So we know it was improper testimony. The question really then is, does it rise to the sufficient level of prejudice in regards to it? And I would certainly argue that it does, because well, there are the three statements, two of which do go to elements that would show in regards to whether or not it would be drugs, which we have a case here where we're already dealing with a substitute chemist as opposed to the original chemist. So there's already inherently that would bring up questions in regards to the testing. And you have an officer who is testifying about the amounts of drugs, who is testifying about performing tests on it, Narcan tests that he was not supposed to be commenting on. So already we have statements where it's essentially kind of vouching for the credibility of a substitute chemist. But then the third statement is easily the most egregious one. I don't believe he had any source of income other than selling drugs. I mean, you have an officer who's just flat out stating, well, he's a drug dealer. I mean, that one is by far the most egregious, and the one that it's really leads to question whether or not the officer was even doing so intentionally. I mean, this is not a rookie officer who's never been involved in a drug investigation, who's never testified.
Objections were sustained, right?
They were, Your Honor.
Accompanied by direction from the judge to strike the testimony and for the jury to disregard it.
That is correct, Your Honor. So, but I think the problem is, and if there had only been one statement or even two statements, then we wouldn't be here today, because the motion for mistrial did not happen until the third statement. For one statement, for two statements, that's one thing, but at a certain point, I mean, you can't put the genie back in the bottle. It's hard to expect a jury to simply ignore.
And that point is 3.
Well, in this situation, I would argue 3, based in large part, too, upon the third statement being as egregious as, obviously there's no exact number because it'll depend on what the statements are. Everything is very situationally dependent. I'm not going to state that every single time there's a third statement, but certainly the more statements there are, the more problematic it is. I mean, the case law certainly is clear that in that
The more problematic the statements are, and also the less compelling the evidence is.
Well, but in this one, I mean, we have an officer who by the third time is just flat out stating, this man's a drug dealer. And an officer who, again, I mean, it is indeed, the trial counsel even did question whether or not these statements were being done intentionally. I believe he made statements along as if the officer was trying to be cute, because it is really hard to imagine that this officer thought it would be acceptable testimony for him to say. And again, this is not an officer who's a rookie. This is not an officer who's never been in court, never testified, but to believe that that was actually acceptable.
In response to the particular phrasing of the questions posed by defendant's trial counsel, and the officer was pointing out that the line of questioning was trying, in the officer's view, to be a little too cute.
Well, I don't believe that I don't remember the exact reading of the question, but I'm fairly confident the trial counsel didn't ask, is he a drug dealer? Do you think he's a drug dealer?
I understand that, but by attempting to suggest innocence, saying that he hasn't ever done anything wrong, and the officer was saying no, except for, other than that, Mrs. Lincoln, how was the play?
I would say that any officer trying to be cute in that regard is certainly, it's not his province to try to have any kind of response.
No, and the judge took appropriate corrective action.
I mean, I think the judge, in terms of the instruction, gave the only, that's why there's the issue in regards to the request for a mistrial. It's not that there's an issue specifically with the instruction itself. The instruction was the appropriate type of instruction. If an instruction was going to be given, it was the appropriate type of instruction. So it's not that the instruction itself was problematic, it's just that I think that by the third statement, considering it was such an egregious one, we reached a point where an instruction just wasn't going to be enough. I don't think there was an instruction that could have possibly gotten to the point where the jury is going to be able to forget and put aside not just the one, not just the two, but the three different statements. I think at that point you have such an egregious action in regards to that a mistrial really was the only proper option available at that moment.
So one of the questions, the one you're referring to, which came up on cross-examination, was, do you know if he was working at the time? The answer was no, he wasn't. I don't believe he was working. Question. Do you know if he had any source of income? Answer. I don't believe he had any source of income other than the selling drugs. Is that not directly responsive to the question?
That is a response that I would say goes far beyond. I mean, again, this is an officer who has to know that would know that that's not a type. I mean, the appropriate response is simply, do you know if he had any other source of income? No. I mean, he's not being asked in terms of, is he a drug dealer? And this is, if officers don't realize that they're not supposed to say on the stand that the defendant is a drug dealer, then something needs to be done in giving officers some kind of training or preparation in regards to testifying before trial. Because if that's something they need to be instructed on and informed about, well, then that would show even more so why a mistrial would need to be declared here in order to send that message they need to know.
I see that your time has come to an end. You can rest on your brief for your argument on the sufficiency of the evidence.
Thank you, Your Honor.
Thank you. For the Commonwealth.
Thank you. Good morning, Your Honors. May it please the Court, Michael Donovan on behalf of the Commonwealth. I'll start with the search warrant issue. The Commonwealth would argue that there was probable cause based on the search warrant. Any defects in the information that was provided regarding CS1, any vagaries regarding the work that CS1 had done in the past were cured, the Commonwealth would suggest, by the controlled buys. I should say, just for the record, that I was the ADA that handled the matter at the motion level and the trial level. The case was briefed by ADA Sweeney from our office. As ADA Sweeney pointed out in the brief, looking at Commonwealth versus Schutte and Commonwealth versus Vieja, the mere presence of an intermediary at a controlled buy doesn't necessarily vitiate probable cause, so long as the buy is otherwise sufficiently controlled. So in this case, the police have information from this confidential source who, according to the affidavit, has provided information in the past that's led to the seizures of narcotics and arrest. The source tells the police that I often buy my drugs from Ferguson through an intermediary, and that's how we set these things up. And then the police do what the police should do, is they attempt to arrange a controlled buy. The source contacts the intermediary then contacts Ferguson. The police pat frisk the source, make sure that he doesn't have any money or drugs, and the surveillance in this case is important. So the first of the two controlled buys is the one that occurs away from the home. Officers surveil the source to the location of the controlled buy that's set up by the intermediary. Another officer surveils Ferguson leave from his home in his car, drive directly to the location of the controlled buy, which is in a public place in Hyannis. Officers observe the intermediary meet with Ferguson, conduct an exchange of some items, then immediately meet with the source, and then the source comes back to the police and says, he middled the deal, here are the drugs that he gave me. So I think what's important here is that the police make independent observations of Ferguson leaving the home, meeting with the intermediary, conducting a hand-to-hand transaction, then going back directly to his home, and that corroborates what the source told them. And as the court pointed out, this isn't a situation where the source gives the intermediary money, the intermediary goes to some unknown third location and then comes back. The source himself or herself is present while this is happening and is able to make observations of this event firsthand. The second buy, the one that occurs 48 hours prior, is the one that occurs inside the home, and I would submit that what's important here is that the source goes into the home with the intermediary. They are in there for a short period of time. They come out together, and the source tells the police, I was standing right there. I gave the intermediary money. The intermediary then bought the drugs from Ferguson, then gave me the drugs, and we came out together. So even in that second control buy, there isn't a level of hearsay. In other words, the source is describing firsthand observations of what happened inside the home. So the Commonwealth would suggest that based on that, there's sufficient probable cause, certainly for the search of the home.
Can you address the officer's testimony on the stand?
Sure.
That seems to be troubling. I mean, this is a case where the gentleman's on trial for distribution of drugs. And essentially the officer, who has 34 years of experience and has conducted and participated in hundreds of narcotics-related investigations resulting in the arrest and conviction of a number of narcotic offenders, basically calls him a drug dealer on the stand. Is that not problematic?
It is problematic, and the Commonwealth would concede that that answer, that statement is not appropriate for the jury to consider. But in this circumstance, the Commonwealth's argument is that the judge did not abuse his discretion by choosing to proceed via a curative instruction rather than declaring a mistrial. I think the context in which the statement was elicited is important. Respectfully, as Your Honor pointed out, this is a line of questioning from the defense attorney on cross-examination, where the defense attorney has already asked the officer, does he have a job that you know about? And the officer says no. Now, the defense attorney doesn't stop there. He then asks the follow-up question along the lines of, does he have, do you know if he had any source of income? Now, of course, this is an experienced officer, and he probably should not respond. He says, I don't believe he had any source of income other than selling drugs. This puts the officer in a really tough position because he's under oath. He's testifying in real time.
I read that argument, and I know you made it successfully in the trial court, but the answer was no. That's not a hard position.
Well, respectfully, what the problem with that is if he answers no, that's a lie, because that's not the information that the officer has. The information that the officer has is that his only source of income was from the selling of narcotics. And again,
well, then the answer is not that I can say, or something. I mean, I think, I knew you were here for the first argument. It does trouble us when we see experienced repeat players who know the rules, either getting very close to the edge or going over it. And, you know, the law may apply in some of those cases in such a way that we affirm despite our discomfort, but it does not mean that we don't feel the discomfort.
Sure. And I would concede that it wasn't an appropriate statement, and it wasn't a statement that the jury should consider. But in this particular case, the trial judge took the night. You can see from the record that this happens at the end of the day. The trial judge takes the night to consider the options. The case is reconvened the next morning, and the trial judge makes very detailed findings of fact and rulings of law, weighing the competing interests, and that's from the transcript of October 18th, 2022, in pages 8 and 11, and makes the decision that this can be cured via a curative instruction. The judge had already instructed the jury both at the beginning of the trial, and then he would instruct them at the end that anything he says that's stricken is not evidence. And then in response to this specific statement, the judge took the extra step, and this is from pages 16 to 18 from the trial transcript of October 18th, of giving the jury a very detailed, pointed, and explicit instruction about disregarding that answer. He tells them not to consider it in any way in their deliberations. He tells them, his answer is not evidence because I have ordered that last answer to be stricken from the record. He reminds them that an indictment is not evidence. He reminds them that the testimony about search warrants is not evidence and that they can't infer guilt from the search warrants. And then he concludes saying, you cannot infer the defendant's guilt on the charged indictments based on this witness's opinion. You must decide who and what to believe and whether the Commonwealth has proved Mr. Ferguson's guilt beyond a reasonable doubt. Solely based on the evidence presented in this courtroom, the witness's answer to that last question is not evidence. So to the extent that there would have been a prejudicial effect, the Commonwealth would suggest that it was cured by that very pointed instruction that made it quite clear to them to disregard what the officer said. And I would suggest that with regards to the other challenge statements, while they were certainly less egregious than that one, in each case the judge struck the answer, in each case the judge instructed the jury to disregard, and as this court is well aware, jurors are presumed to follow the instructions of the trial judge. With regards to the last issue, whether there's proof beyond a reasonable doubt, I would suggest that on a Lattimore standard, all of those plus factors, the presence of baggies, scales, that the cocaine was packaged in 3 different bags, the lack of evidence of indicia of personal use satisfies the Lattimore standard.
I want to ask you a little bit about the personal use and the coke. What indicia of personal use would be necessary for powder cocaine?
Well, I think that it's on a case-by-case basis, but certainly there was testimony, I think both from the expert, that sometimes you might see straws, cut-up straws with
There was
residue.
cash, right?
Right,
Sometimes you might see cash that's rolled up to be used as a straw.
correct. There was no evidence of that.
There was no evidence of cash?
Well, there was evidence of cash, but there was no evidence that cash had been rolled up and used as a straw. You might see.
Coke can be applied to any mucous membrane, right? So all you need is your hand. Most people have a hand.
Sure. And the Commonwealth isn't suggesting that the lack of indicia of personal use by itself carries the day, but it's just one factor that the jury is allowed to consider. And I would suggest that that's a factor that they could appropriately consider and weigh in this case. So unless there are any further questions, I would rest on ADA Sweeney's brief.
Seeing none, thank you. Thank you both.
Thank you.
Case is submitted. And we move to the third of our 3 criminal matters, case number 2023 P1326, the Commonwealth versus Edson Lopez. And just as a reminder, we will be taking a brief recess following the conclusion of the argument in this case.
Good morning, Your Honors. If it pleases the court, Arne Hansen for the Commonwealth. We are here because in 2016, the defendant Edson Lopes pled guilty to a drug charge that was amended down from trafficking to possession to distribute as part of a plea agreement. Several years later, in 2022, he filed a motion for new trial stating that the basis of which was that he was not advised by counsel of the fact that he could be excluded from admission to the United States as a result of his 2016 plea. Now, in 2016, he was given a full colloquy. He was advised of his alien rights by the judge, which I understand doesn't control. The issue here is what advice counsel was given. But he and counsel both signed the waiver of rights, which went over the applicable rights in this case. So that waiver of rights form states explicitly that exclusion from admission to the United States is one of the potential consequences if he's not a U.S. citizen, which he is in this case. So defense counsel signed that he went over those rights. The defendant stated that he understood those rights, and part of his motion for new trial counsel who did the plea in 2016 also reiterated that he went over those rights. So the evidence suggested that the defendant had been advised by trial counsel that the plea could result in exclusion from admission to the United States.
This concern goes into what we call the Padilla category of incorrect advice. It's not that he could be excluded, but that he certainly would be.
Yes, that's certainly a fair assessment, but this is the preface to my argument. It is my belief that the motion for a new trial shouldn't have gone beyond that point, where the evidence suggested that he understood his rights at the time of the plea. But the argument that I'm making now on appeal, where the motion for new trial was allowed, is that the judge who allowed the motion erred in two distinct ways. One, he found that the defendant had met his burden of demonstrating that it would have been rational for him to reject the plea based on his special circumstances. And that decision in finding that there were special circumstances in this case is not in line with the case law from this state as well as federal case law.
And I think he may have looked at the wrong moment in time when he was making that assessment. But let me ask you this question. Are you pressing for an evidentiary hearing? Is that what you want?
The first argument would necessitate not having a hearing and just reversing the judge's order and saying there are no special circumstances. This motion for new trial shouldn't have been allowed based on the circumstances. So that would be my first argument, and I think that's the appropriate argument. There was also, my secondary argument is there was some confusion as to what advice counsel actually gave. So in this case, the judge credited a portion of the affidavit submitted by attorney.
But I wouldn't have instructed him about admission back into the country, right?
Correct. So Attorney Krauske contradicts himself where he states that I wouldn't have advised him if he traveled abroad that he wouldn't get back in, but then in the next sentence writes, I advised him of the rights that were included on the form, specifically exclusion from admission to the United States, which is exactly the same thing as saying, hey, if you travel out of the country, you're not going to be able to get back in.
But if we agree with you on the prejudice prong, we don't need to reach the evidentiary question that you've raised.
Correct. So with respect to the prejudice prong, in order to show prejudice in this type of case, the defendant has three possible avenues. One, that there's a substantial ground of defense. That was not an issue in this case. The defendant, in his motion from trial, stated they could have filed a motion to suppress or dismiss, but didn't identify it. This was certainly, or didn't identify what type of motion or what avenue they could have followed. So that's not really the issue here.
Is there any issue in this case about the drug lab?
Chemist.
No.
The chemist?
No. With respect to reasonable probability of the entering another plea.
Was the chemist still working for the Commonwealth at that time, or had the chemist not been working for the Commonwealth any longer?
I'm not sure. I'm not entirely sure why we're talking about the chemist.
At what time? The time of the...
At the time of the trial.
Or the plea?
Or the plea.
I would have to defer back to the transcript. I'm not sure what we're talking about. My point is that Judge Glennie, in denying or allowing the motion to suppress, relied on special circumstances. The argument here is that there were no special circumstances at the time of the plea with respect to this defendant.
I'm just trying to figure out what the strength of the government's case was at the time of the plea.
With respect to, the government would have offered testimony from the officers involved who executed the search warrant, as well as My understanding is that the chemist does not work at the lab now. So since the motion for new trial was allowed, I followed up on the status of the drugs. The drugs are still in evidence. They would potentially have to be retested because whoever, a substitute chemist could not testify to the weight. So potentially an officer would testify to the weight, which is an alternative, or they could be retested.
So the government had a strong case at the time of the plea?
Correct. That is the argument that I'm making. Now, with respect to special circumstances, the defendant in this case points to two specific facts, that he moved here when he was 13 and he lived here for 9 years when he did the plea, and that he also had family members here, the family members being his parents, his siblings, as well as aunts and uncles. Now, this court has routinely held that having family members and being in the country alone is not enough to warrant special circumstances. So the cases that I cited in my brief were DeMarca, Rodriguez, and Mercado. I don't believe I need to get into the details of any of those, but those all hold that family members and being in the country for a long time does not warrant special circumstances. There are circumstances where having family members do become special, but that's in the case of dependents. So there are several cases that I cited within my brief that speak to that issue, specifically Martinez, Aurelius, Lee v. U.S., which is a federal case, and U.S. versus Ruiz. Now, in Martinez, that individual had been here since early childhood and had 3 kids at the time of plea, all of which depended on him. Similarly, in Aurelius, he had been here for 30 years, had 2 children who relied on him at the time of the plea. Lee v. United States, he had been here for 30 years and had parents that relied on him or dependent on him at the time of the plea. U.S. versus
We're
Ruiz.
familiar with the cases. So in this case, he's 21, no children at that time, right?
Correct. So had he had children that were dependent on him at the time of the plea, that would certainly support allowing the motion, and the arguments would be completely different, but that's not the case here.
And he didn't make any mention of going, I think he was from Cape Verde Island, is that right?
Correct.
About having to go back to a war-torn country or anything like that. He didn't raise any issue such as that in his motion, or did he?
That is correct, and those are arguments that are cited in Lavarenko as well as in Aurelius. He's from Haiti, so certainly that would not be a country that you would want to go back to at this particular point in time. Lavarenko was a refugee who was seeking asylum. He faced potentially death if he was returned to Russia. So that's not, again, the circumstances in this case. Now, there's also cases from the SJC that the defendant relied on in his motion for new trial, but as well as Judge Glennie in allowing for the motion for new trial. And I would state that those cases are substantially different from the case at bar. So Lavarenko, as I stated, was an asylum seeker who, again, would be potentially put to death if he had returned to his country of origin. And in that case as well, the court found that that defendant had a substantial ground of defense, which is an element that is missing here. So independent of special circumstances, the substantial ground of defense was enough to grant the motion for new trial, and certainly in combination with special circumstances. In DeJesus, it's the same thing. There was a substantial ground of defense that was the basis of overturning that conviction and allowing for the motion for new trial.
I mean, the reason that the two are considered in combination is that they go to the central question on the prejudice prong. Would a rational person in the defendant's circumstances reject the plea and insist on going to trial?
Correct.
And in this case, in the third element that enters into that calculus is the nature of the disposition. In this case, the defendant facing a 5-year mandatory minimum on conviction to which he had no identifiable defense was given a deal that involved straight probation on a lesser charge. Is that correct?
Yes, so he was given a suspended sentence, a 2 years in the House Correction sentence that was suspended for 2 years, so he's put on probation for 2 years. He completed.
I realize that it was a sentence for incarceration suspended, but he avoided any jail time whatsoever.
Correct.
And that's a house sentence, not a state prison sentence.
Correct.
At 21 years old.
Correct. And that's where the seminal case that adopted Padilla in the Commonwealth is Commonwealth v. Clark. The circumstances in this case are very similar to the circumstances in Commonwealth v. Clark. Now, Clark was also arrested for drug offenses, and his min-man was 12 years, which was pled down as part of the plea to 6 to 9. But he avoided more state prison time, and the court found that based on the strength of the case, he would have been deported either way. So if he had taken the matter to trial, because there was such overwhelming evidence against him, he'd be in the exact same position where nothing is certain, but it was almost inevitable that he would have been found guilty after trial.
But look, even in it's a sliding scale because take Lavarenko, where he knows that he's facing almost certain execution if he returns to his country of origin. No matter the strength of the evidence, what's the alternative? You're better off to roll the dice, even if you've got a bulletproof case against you, than to take it, because even that would delay your inevitable deportation.
Yes, that's certainly fair, Your Honor. I think I've addressed the first point. With respect to the dispute of fact, it's unclear, based on the affidavit, what advice Attorney Krowski actually gave. And the issue here is that the judge credited a portion of it, stating that he didn't give him advice regarding exclusion from admission to the United States.
It's I have to say, a fair inference, isn't it, that no one told him that if he left the country he wouldn't be denied readmission? Because if he had known that, he wouldn't have attended his grandfather's funeral.
The issue here is that the next sentence in Attorney Krowski's affidavit completely contradicts. So what Attorney Krowski says is, I didn't specifically advise him that if he traveled abroad and re-entered, that he could be denied admission into the United States. That is a very specific example that is within the subset of exclusion from admission to the United States.
I understand that. But that's what happened. And if he wasn't advised of that consequence and then suffered that consequence,
I understand what Your Honor is trying to say, but I would say that he was advised of the larger general category of you could be excluded from admission to the United States. There are presumably dozens of ways that one could be excluded from admission from the United States. So holding that, being advised of one specific subset of that at the exclusion of all the others.
But being denied readmission, I mean, inherently is being denied readmission after leaving, right? I mean, that's what it is.
Yes.
That is one of the foundational elements of the required advice.
Yes.
One of the potential consequences that we are concerned with.
Yes. So I think it's not exactly clear what Attorney Krowski advised his client of.
No, but again, just not to belabor the point, and again, if we agree with you on prejudice, it really doesn't matter. But
Correct.
But I guess as I sit here, it seems to me a fair inference that if Krowski had told him that if you leave the country you won't be able to come back, he wouldn't have left the country.
That's fair, but that would also be taking the defendant at his word.
Sometimes we do that.
Yes.
And Krowski, but and drawing rational inferences from the circumstantial evidence.
I mean, isn't there, oh, sorry. I guess, to me, the paragraph 5 of Krowski's affidavit is not quite as conflicting as you seem to read it, and I think there's a reading of it that is consistent with both the signed form that was, is it Lopes? It's Lopes, not Lopez, right?
I believe it's Lopes.
Okay, thank you. That Mr. Lopes signed, which is that Mr. Lopes was informed that the conviction would lead or could lead to deportation, removal, or denial of a citizenship application, but not specifically told. Also, one of the things that this weird word removal means is if you go out, you won't be allowed to come back.
I understand what Your Honor is saying, but I'm looking at a sentence. The following sentence starts with, however, I would not have informed them the specific consequences about reentering the U.S., and then the next sentence is, along with informing Mr. Lopes of potential immigration consequences listed on the waiver of rights form. So he says that he advised the defendant of the waiver of rights form consequences. One of the specific consequences on the waiver of rights form is exclusion from admission to the United States. So that is the first, so it's my record appendix, page 90. It's the second page of the waiver of rights form in the first paragraph.
Deportation or exclusion from admission to the United States.
Correct. So Attorney Krowski says, I advised him that he could be excluded from admission from the United States. But in the prior sentence, he says, I didn't advise him of that, and that's the issue.
Okay, thank you.
Do you think it's reasonable for the defendant to say, well, that doesn't really apply to me because I'm already in the United States? So for his case, it would be readmission to the United States versus admission to the United States.
I think that's a reasonable.
21-year-old kid.
I think that's a reasonable interpretation from Your Honor, but I don't think it matters because what prevails here is not how the defendant understands the warning or whether he understands it or not or how he interprets it. It's whether or not the warning was given by the judge, which I understand.
It matters whether he understands it. What do you mean whether he understands it or not doesn't matter?
Correct. It's what advice defense counsel gave, and in this case, defense counsel said, I gave him the required advice.
Your time has come to an end. We'll hear from counsel for the defendant.
Thank you.
Good morning, Your Honors. Paul Tolan for Mr. Edson Lopes. I'd like to address the issue that we were just talking about concerning the affidavit and move backwards to talking about the special circumstances. We're already talking about that right now. When I read this affidavit from Attorney Krowski, I understand that, from my understanding, he's talking about the waiver of rights form. Every plea attorney has to go over the waiver of rights form no matter what in order for a plea to go through. So, of course, they go over the general alien warnings. And Padilla.
To begin, Attorney Krowski has no real direct memory at all about what happened in this case, right?
That's correct. I asked him about what were his normal practices at the time since it was in the past, and he said he would have informed him that he would be deported and would be denied naturalization, but he said he likely would not have informed him about the specific consequences of exclusion from admission to the United States. And that's what the issue is here. Because it would be illogical for someone to just travel out of the country and then have problems come back in with immigration. It would be logical just to remain in the country with your lawful status here as a lawful permanent resident.
What if we assume that he was incorrectly advised? And if we start, in other words, from the hypothesis that I offered earlier, that we can infer that he didn't know that if he left the country he wouldn't be allowed back in, or he never would have left to go to attend his grandfather's funeral. That's unfortunate for him, but how does it bear on his decision to reject the plea at the time and instead go to trial where he had no identifiable defense?
So let me move back. We're moving back to the first
And back to the prejudice
correct.
prong, yeah.
Correct, okay.
Because special circumstances, my reading of the cases, and I've had a few of them, is consistent with what we heard from the Commonwealth. Typically, there are much more dire consequences facing someone in Mr. Lopes' circumstances to warrant rejection of a plea that avoids 5 years of prison time for no jail time whatsoever.
I understand, Your Honor. And the one case that kicked this whole off was PD v. Kentucky, and that was a drug case that involved a lawful permanent resident. And this particular case is almost similar to that. In this particular case, he's a lawful permanent resident.
Yep.
He came in this country when he was only 13 years old, from September 11,
How old was Padilla?
2007. I'm sorry?
How old was Padilla?
How old was
Padilla?
I don't know how
And
specific.
where was he going back to?
Doesn't say. He had been in the U.S. for more
Suffering
than 40
mandatory
years.
deportation, but it was the same thing. It was a drug trafficking offense.
No, I understand the nature of the underlying defense, but when we start looking at special circumstances, we're really looking at the individual circumstances of this defendant.
Correct.
Quite often, in the cases where we found special circumstances, the individual doesn't even speak the language of their native country. They have no support network, and they are dependent on a support network here. They are facing dire consequences in the country of origin, a war-torn battlefield, political unrest, asylum from execution by a corrupt government, that sort of thing. We have, as the Commonwealth also identified, we have the circumstances where a defendant is not himself dependent on a support network here, as the defendant was in Cano, but has others who are dependent on his continued present, minor children, that sort of thing. We don't have that. At least we didn't at the time that he was faced with the question whether to take or reject the plea. So when we look at this defendant, who's getting no jail time on a 5-year prison, has no identifiable defense, and what he needs to do is keep his nose clean and stay in the country. If he'd been properly advised, he probably would have done just that. But he wasn't properly advised. He left and was denied readmission?
I think anyone in his position would actually reject the plea bargain and take his chance at trial, given the fact that he has his whole family here, and family is the most important thing that I believe everybody in their lives. It's the only thing you got. Without family, you have nothing. And his whole family was here. The only family he had was...
Except for his grandfather.
Except his elderly grandfather he went to the funeral for, and that was it.
Once he's convicted, he's going to get deported, period, right?
He is. But why not take that chance, if that's your only chance to remain in the United States?
It's not his only chance to remain. He remained in the United States for 6 years.
That's correct.
After he took the plea. And it was only when he left and was denied readmission that he suffered the consequences. That is very unfortunate for him. And had he been properly advised, he wouldn't have left the country. I get that.
Yes.
But facing the choice that he had in 2016, he would know that taking the plea, that going to trial, he would have 5 years of prison time, but he would also be deported.
That's correct.
And by taking the plea, he avoids jail time and can remain in the country.
Yes, but the case law states that the trial judge has to take into the totality of the circumstances and see if a reasonable person in his position would reject that plea. I believe it would be rational for someone like that, who's someone who came here when he was 13 years old. He hasn't been back to Cape Verde except to go visit his elderly grandfather who was passing away. He also had his whole family here. He also had lawful status. He could have become a United States citizen. There's case law stating that a person's fervent desire to become a U.S. citizen is a special circumstance, and he did state
Isn't that true for each of the defendants who faces deportation?
I would say so, but I'm just saying that's what the case law states, Your Honor.
What is the case that you would point us to that presents circumstances the closest to yours where special circumstances were found?
I would say Commonwealth versus Cano, with the Colombian citizen, who has been back to his country.
That was I think I had some familiarity with that case.
And also Commonwealth versus De Jesus, I believe that one.
Did I write Cano? Is that the one I'm thinking of?
Cano is the one with the Colombian.
Yeah, but also severe cognitive impairment or dependent on government benefits and a support network here in the United States.
Sure, Your Honor, but not every case is going to be exactly the same.
I understand, not exactly, but those are two very, very significant factors that were present and really determinative in Cano that are absent here.
He was also losing his lawful permanent resident status, just like my client, and losing his ability to...
I think Cano also was 3 years old when he came to the United States. If I'm always reluctant to rely on my memory, but considerably younger than 13.
I don't recall the age of Cano, but
if he had gone to trial,
my client was 13.
If he had gone to trial and lost, all of those bad things would have happened to him anyhow, right?
Correct, if he was arrested by ICE.
Went to trial and lost. You have a 21-year-old kid doing 5 years mandatory state prison time. State prison time is very different than House of Correction time. You agree with me?
I agree, Your Honor.
Okay. So that's not something that anybody would sign up for lightly, particularly at that age. And he's still going to end up getting deported. So I'm not sure what the appeal is to go to trial when the case isn't when the defense isn't very strong.
I understand that, but a non-citizen faces a different calculus than a citizen in the United States. And when you think about everything that you're going to lose and go back to a country that you've never been to for so long, and now you have to start over and live there, you're starting from ground zero now.
Let's assume that he had been given there was no question that he was told, if you leave the country, you won't be able to come back in. Think he would have taken the plea still?
No, I don't think he would have.
You don't think he would have?
I think if he was properly advised of the specific consequences.
You don't think he would have taken the plea?
No.
Because he wants to be able to travel back and forth out of the country?
Yes. I think he also wanted to become a United States citizen.
But he hadn't done that had he done that at all since he's been here?
No, that was the first time he's ever traveled, but it was to visit.
And how old was he at that time?
At the time he visited his grandfather?
Yeah.
That was 2022. So he would have been, sorry, I'm doing my math.
27.
27-ish, right?
So he'd been here for 14 years and hadn't left.
Correct.
But it was important to him.
Especially in that circumstance, Your Honor. And then you can see how important family was to him, given the fact that he went to go
Properly
see his
advised, a rational person in his circumstances would have stayed in the country, extended his sincere regrets for his inability to attend his grandfather's funeral, but preserved his opportunity to remain with the rest of his family.
I'm sorry, Your Honor.
I said properly advised. If he knew what the consequences would be, there's no doubt in my mind that he would have sent his sincere regrets for his inability to attend his grandfather's funeral, but remained in the United States.
That's correct. I believe he was
But
not
that's,
in trouble.
and he would have made a comparable decision, rejecting the plea but remaining in the country to avoid jail time when he was 21. Knowing that he could remain in the United States, he just couldn't leave. The sad part about this case, and I understand it's quite sad, is that he didn't know that he was going to be denied readmission when he made the decision to leave. But that doesn't bear on the reasonableness of his choice to take the plea at the time that he took it.
I believe it does, Your Honor, because those are the three specific consequences that a judge advises a defendant before they're taking a plea. And if he was informed, you will not be able to come back in this country. You will not be come back in safely without facing possible deportation. That's what should have been told to him. And he wasn't informed of the Immigration Nationality Act, 212 or 237. Those are the two specific statutes from the INA that you should have been advised of, which he wasn't. He was just told, you would be deported or you would be denied naturalization. That's it. And then he told him to go talk to an immigration attorney to get more specific advice, which also is an inference that he didn't know the specific consequences of the specific immigration consequences here.
The form that the judge has to read in going through the colloquy is that you'll be denied admission to the United States, correct?
That's correct.
And so he got that.
Correct. He was told he could be denied admission, which is not a proper substitute for the attorney's advice under Commonwealth versus Lavarenko.
Not a proper substitute for the attorney's advice, no
Correct.
question. But the attorney says, I went over everything on the form with him.
Yes, as they have to, and as the plea attorney, and as the judge has to confirm if they did do that, and they have to sign off on that form.
And so is your point that either one, he told him he was likely not going to be readmitted when he knew he wasn't going to be readmitted, or that he said admission and not readmission? I'm trying to figure out where if the lawyer gave him the instructions as on the form, where did he fail?
He didn't tell him specifically that he will be excluded from admission, and that he was not able to freely travel in and out of the country.
So it's the
And
use
additionally-
of could
and
when
additionally-
it should have been will.
Correct. If there's any more further questions, I would rest on my brief.
Seeing none, thank you both for your argument. The
Thank you,
case
Your Honor.
is
Thank you for your
submitted.
time.
We will be in recess and resume at 11:10.
All rise.
The next case on our list for hearing, and the first of our three civil matters, is case number 2023 P782, Joanna L. Mannion and another versus Daniel A. Dittler. The appellant will be the sole party arguing. The appellee did not submit a brief. This case is partially impounded. Just a reminder to refrain from referencing any of the impounded material. You may proceed.
Good morning, Your Honor. May it please the court, Paul Neustadt for the appellant father. I've raised two issues in my brief today. I'll address the issue of the actual allocation of the college expense and the issue of bias on the part of the trial judge. I'll address the issue of bias first. The trial judge's apparent bias deprived these parties of the unprejudiced and impartial determination to which they're entitled, and as a result was therefore inimical to the administration of justice. Now, in my brief, starting at page 36, I pointed out a number, I think 5 or 6 instances that the father considers were the result of bias. But there are more. As you know, briefs are limited in length, and I was only able to put in a certain amount. For example, on page 153 of the first volume of the appendix, finding number 20, says the father claims incredibly that the funds that he had already accumulated in a fidelity brokerage account on the child's behalf that were designated for the child's education in the amount of $377,255.71 are no longer available for use towards the education. See Exhibit 35. Well, first of all, there's no Exhibit 35. There are only 19 exhibits. But more to the point, the funds, in fact, are no longer available. If you look at the father's financial statement from the time of trial, these funds just aren't there.
So, can I just ask about that? I know.
I'm sorry, Your Honor, I can't hear you.
It doesn't direct right on the bias question, but on the funds themselves. You say the funds are no longer there. So does that inferentially mean they were there at one point?
They were there when the father was.
The college education.
I'm sorry, I didn't hear.
The funds for the college education were there, existed at one point.
Yes, the father was required to maintain that account and contribute to it until 2015.
And then he spent it down?
He used the funds for other purposes, yes.
What were those purposes?
As detailed in the brief, he used
He
it.
invested some of it. He paid off the mortgage, I think, was one of the things.
Yes, he paid an IRS debt. He paid off the mortgages on his house.
I think he invested $90,000 in something else. I forget exactly.
He bought the company, and he also maintained all of his obligations with regard to his child. He paid for private school. He paid for child support.
The agreement was that he would pay for the college education with the funds from the bonus. Right?
Yes, Your Honor.
And at the time he entered into the agreement, he was receiving the bonus.
Yes, Your Honor.
The agreement wasn't he'd pay for the education with the funds from his future bonus.
That's correct. There was no mention of future. He was supposed to accumulate, until the 2015 agreement, he was supposed to accumulate the funds in the account. After the 2015 agreement, he was no longer obligated to maintain the separate account. He just said he was to pay from the bonus.
So the argument is that in 2015, those funds became fair game?
Yes, he was no longer obligated to maintain the account, as this court found.
But I'm not talking about the account, right? I think that's a little bit of a red herring, because money is fungible. But there were funds, wherever they were held, under a mattress in an account, it doesn't really matter, that had been earmarked for the child's college education. And in 2015, the agreement between the parties changed. And I think you'll probably agree that once the new agreement was in place, the old agreement really had no legal relevance, right?
Yes, the parties were specific about that in the 2015 agreement.
So the new agreement is you're going to pay, I'm going to pay for all of it. Your client says, I'm going to pay for all of it, and I'm going to use money from my bonus to do so, right?
Yes, that was their agreement.
And he had, in an account under the mattress, doesn't matter, already $374 and some odd $1,000 from his bonus.
Yes. at that time, at 2015, yes.
So regardless of whether he still had to maintain the account or not, he still knew the obligation was he had to pay for the college education with the money from the bonus.
Yes, but he wasn't earning bonus, and he hadn't for several years.
He had already earned enough of the bonus to pay for the college education.
But he wasn't required to keep the bonus and maintain it.
He wasn't required to keep the account, but he was still obliged to pay the tuition.
So I don't know why he just didn't set that money aside then and not use it for other things, because his obligation remained the same.
His obligation was to pay it from the bonus.
And he had the money from the bonus.
Well, he had money. As Justice Hirschfang pointed out, money is fungible. So,
Which
what
is
if he didn't-
why the argument that the preservation of that particular account was an essential element of his obligation to pay is not particularly persuasive.
But how far back does that go? For example, if he had had a bonus when the child was born and it stopped when the child was 5, would he still have the obligation to pay based on the
He
bonus
had an
that he
account that
once
held the
made?
bonus. I mean, the panel that previously heard this, the previous appeal in this case, in rejecting the way that the judge treated the obligation to preserve the account, said that the account doesn't bear on the obligation. He has to pay the tuition, and that was the obligation.
Well, I don't agree with you, Justice Green. I think what the judge said was, what the panel said was that the trial judge rested her judgment on the idea that he was supposed to maintain this account and he no longer had an obligation. Then the trial judge changed their agreement from pay from the bonus to pay without regard to where it comes from. In fact, when the judge pointed out that he had $515,000 in a separate account, that was an IRA. I'm not sure if it was an IRA. It was a retirement account. So she wasn't looking at it. She had changed the obligation.
Right, she said from his assets and...
From assets and income. And that was after she had just found that he had no income. And the only income on which she based the child support calculation was the attributed income.
Isn't the question before us on this appeal whether the judge's written findings are adequate to support her ruling that your client is responsible for more than 50% of the child's college education determined by the costs at UMass Amherst?
It's certainly a major part of this appeal, yes, Your Honor.
I'm sorry, just to what extent, could you address that, please?
Could you be more specific about your question?
Sure. I mean, there are a ton of written findings. I understand that, in your second argument, which you raised first, you take issue with the evenness of those findings and say that they support an inference of bias. And I don't mean to not attend to that argument, but it's not part of what I'm asking you about now. Looking at the findings as they are, in what way do they not support a determination that your client can be found, and by supported determination, I mean, that they're not adequate to support the order that your client pay more than 50%?
Well, for example, Your Honor, with regard to the uninsured medical expenses and the extracurricular activities, which the trial judge split 60-40, with my client paying 60%, she entered no finding or no rationale or no explanation of why that differs from the college.
Does she have to do that?
I think so.
Why? Why do you think so?
Because I think the judge's decision has to be founded on findings, and there are numerous cases on that, and it's accepted in Massachusetts law. So if she's going to say, pay for college this way, but pay for the uninsured medicals that way, she needs to explain the difference and why she's treating them differently.
And the findings include findings about your client's earning capacity and his savings and his available financial, the money he has here, there, and wherever. Why are those not adequate to support the ruling by the judge?
Well, for example, there are no findings explaining why the judge looked at my client's finances, but didn't look at all at the mother's finances. There are no findings explaining why when the judge found that my client wasn't truthful with regard to, it wasn't credible with regard to the food expenditures. There are no findings explaining why $420 a week for my client is not credible, but $400 a week on the mother's financial statement for food is credible.
It's not routinely required for a judge to make specific subsidiary findings to support a conclusion as to credibility. The judge has exclusive prerogative over determining credibility of
I'm sorry, I didn't hear the last part of
I said
that.
the judge has the sole prerogative to determine witness credibility.
Yes, but the judge has to make findings that make apparent what she or he was thinking.
Not on credibility.
I'm sorry?
Not on credibility. The judge can say nothing about why they determine credibility. I mean, they can say,
Correct.
They can offer something, but they're not required to do so.
Of course, but where there is documentary evidence.
I just want to
suggesting-
go back for a moment, if I can, to something you said earlier, because the continuing insistence that the sole source of funds for the tuition payment, and for that matter, the obligation to, itself, is from bonus income, that overlooks, I think, the statement that the panel made in the previous opinion at page 8 that said the judge could have appropriately treated the loss of the father's bonus income as a material change warranting modification of the requirement that the child's college expenses be paid from bonus income. So that the panel expressly recognized that the change in the structure of the father's income, eliminating bonus income as a potential source, warranted a change in the parties' agreement, severing the obligation to pay from the source of those payments.
Well, the problem is, Your Honor, that the first thing she did was deny the modification on her, on the First
That's
Amendment.
why it
judgment.
went back.
And we went back.
That's
And
why
then-
it went back. And the panel gave direction that, in my view, expressly negates the argument that you're pressing here that the sole source of available payments for the
No.
obligation to pay is from bonus income.
I'm talking about after that. The judge looked at the appeals court opinion and then, taking that into account, said, okay, I'm going to deny your complaint for modification. Then the father pointed out to the judge in a motion to amend that that leaves the 2015 agreement in force, which says that tuition and expenses should be paid from the bonus. In response to the motion to amend, the judge issued the Second Amendment judgment when she said that the father should pay it without regard to where the money came from.
Right.
But that's not what the parties agreed. And in the first panel...
But the panel previously said that what the parties agreed is a change to that is warranted by a material change in circumstances.
But the panel also said that when there's an agreement, even if it's not an independent agreement, even if it's merged into the judgment, the trial judge should also look at what that agreement provided and take that into account. That was in the first panel.
So if that's the case, doesn't that help us understand why the focus was on his monies and not hers? Because the agreement was he would pay for the college education, not
The
her.
agreement, well, I'm sorry, were you finished, Your Honor?
I am.
The agreement, Justice Desmond, was not just that he'd pay for the college education, but that he would pay for it from his bonus. And that was from the time the child was born, that was their agreement.
But
I
we can't,
understand.
we're not looking at that early part. We're just looking at 2015.
Right.
I mean, I hear what you're saying is that that never
Again,
changed.
we're also not just looking at 2015 because from and after the point of the material change in circumstances, the loss of the bonus income, the panel recognizes that that change could warrant a shift in the required source without alleviating the requirement to pay.
But there are no findings explaining that. The trial judge did not say, I'm making this and I'm doing it because he still earned the bonus for all these years. So I'm going to hold him accountable for that bonus.
Well,
She didn't do that.
Can't we infer that? You don't think we can infer that?
No, I don't, Your Honor.
It wouldn't even matter if he had had bonus
I'm sorry.
before, if he had available funds from any other source.
But that's the point. The parties
Yes, it is.
didn't, the parties didn't agree, as I said in my brief, The parties didn't agree that the father's responsible, it doesn't matter where he gets the money. The parties agreed on the source of the money. So if the source wasn't available, the parties went back to court to say, okay, this doesn't work anymore.
The parties didn't go back to court. This isn't a joint motion, right? This is his motion.
No, my client went back to court
So
to
this
say,
is
I don't have the bonus anymore, we need to change it.
Right. I don't have it anymore because I spent it down.
No, I don't have it anymore
Oh,
because I'm not
getting
earning
it
it.
anymore.
And in fact,
And I got let go from Fidelity.
at the time of trial, he hadn't had a bonus in a year and a half. So that brings me back to my question. If he had only earned a bonus until the child was 5, would he still be held responsible for the following 15 years of bonus?
That's not the facts before us.
And it's also not the contract before us. I mean, if there had been a desire to have a contract that said, I will be responsible for paying for the child's college education from the funds of my bonus, so long as I remain employed and I'm still receiving a bonus, that's not difficult to draft, and that's not what the agreement says.
I think that is what the agreement says, because he can't pay from the bonus if he doesn't have a bonus from which to pay.
How much was his bonus?
A substantial amount of money, I don't know.
Right, like $1 million?
I don't know, Your
I
Honor.
want to say 1.3, but I'm not sure. Anyhow, in 2015, he didn't stop getting the bonus until 2019, is that right?
I think he was terminated as of December 31st, 2018.
Okay.
And
So
subsequent,
we presume that's when the bonus stopped?
I assume so. I don't know, Your Honor.
All right. I see that your time has come to an end, and there is no argument from the other side. The case is submitted. Thank you.
Thank you.
The next case on our list is case number 2023 P618, Mikhail L. Baye versus the Massachusetts Department of Transportation and others. Apologize if I mispronounce the name.
Yes, Mikhail L. Appellant pro se. Thank you, Your Honors. I'd like to begin by addressing the procedural posture of this case, and then move on to discussing the broad, far-reaching implications of this litigation. First, I will chronologically elucidate the course and tenor of this litigation thus far, using the government's own words.
Can you point that mic up? You're kind of tall, so I can't really...
Yes.
All right.
Is that better?
It is, thank you.
Thank you. February 23rd, 2021. An oral argument in this court, prior counsel for MassDOT, quote, conceded that MassDOT must comply with its own regulations in promulgating SSRs and speed limits. Counsel also agreed to argument that, quote, one charged with speeding might, in defense of a speeding citation, challenge the lawfulness of the promulgation of the posted speed limit sign. May 19, 2022. At a CMVI motion hearing in the district court, intervening counsel for MassDOT stated, quote, I note that Mr. Albea has a civil action that's pending in the Middlesex Superior Court with the identical issues here, saying that the DOT did not follow its protocols and regulations in setting the speed limit, and that may very well be the proper form for that question. A simple civil motor vehicle infraction appeal is not the form for that. July 25th, 2022. Counsel serves and ultimately files his state defendant's motion to dismiss the amended complaint over 2 months after the CMVI motion hearing. In his supporting memorandum, he stated, quote, Mr. Albea does not argue in this direct appeal of his citation that SSR number 7659 was invalidly promulgated. Counsel further stated that dismissal was warranted because, quote, there is another, more definite remedy to plaintiffs aggrieved by speed regulations, challenging individual citations in traffic court. February 16, 2023. At the Rule 12 hearing, counsel, reversing course from his paper, stated, quote, I would like to emphasize that we don't come back yet again if we win solely on standing. I would like to also ask the court to rule on the merits. Given these concessions, representations, and waiver, it is perplexing that we're here on appeal from allowance of a motion to dismiss. It would appear that everyone is in agreement. A merits determination to declare and clarify in the Superior Court the respective rights and obligations of the parties is appropriate. Subject matter jurisdiction is not a seriously contested issue here, and in fact, the government is a stop from contesting it. And yet, in spite of the government's brazen shell game, the Superior Court, in effect, sua sponte dismissed the complaint without legal grounds to do so. Instead, I should have had the government's answer a year and a half ago and proceeded from there. Vacatur and remand is clearly warranted here to correct the erroneous dismissal of the complaint. Second, I'd like to address the broader importance of this litigation. This case is about the most common...
Before we get there,
yes.
you're pressing for remand? That's what you want?
Yeah, I would think that would be necessary for a declaration to enter. I think the Superior Court would have to actually enter the declaration, my understanding.
All right, so what were you going to say now?
Of course. I'd like to address the broader importance of litigation as well. So this case is about the most common scenario in which the government claims an exception to the warrant requirement, amounting to hundreds of thousands of warrantless seizures per annum, regulatory speed limit violations. And yet, the appellate courts of the Commonwealth have never specifically subjected this ubiquitous exception to meaningful judicial scrutiny. I find this baffling, especially considering the SJC's recent jurisprudence in cases such as Buckley and Long, where the court has struggled to grapple with the enormous discretion police officers have to make warrantless traffic stops. The government has capitalized on this lack of oversight and expanded this exception far beyond its legitimate scope, which is acutely demonstrated by the egregious facts of this case, making this case the perfect vehicle to finally scrutinize and rein in this exception. I welcome any questions from the court.
Yeah, when you're talking about the requirement of a traffic engineering study in order to set a speed limit, you refer, I think, unless I'm in the wrong spot in your brief, to 2017 MassDOT procedures.
Correct.
And this SSR 7659 predates 2017 by a good 20 years, is that right?
Correct.
So is it your position that the 2017 MassDOT procedures require the Massachusetts Department of Transportation to reset the speed limits on all of the roads in the Commonwealth by using engineering studies?
So I think the procedures, they define what a regulatory speed limit is. And, I think they do make an argument about, at the time it was promulgated in 1996.
Let me just interrupt you for a second.
Yes.
Can you answer that question, yes or no, and then tell me what the explanation is?
So, if there were other speed limits that didn't have an engineering study, I
But
think
there are.
There are, correct.
Right? The SSR 7659 covers like a gazillion roads, right?
Anything that was 60 or 65 prior to the national maximum speed limit in 1974. So, they would have an obligation to correct.
But the underlying question really is, what was the effect of the adoption in 2017 of the regulatory requirement for a speed study incident to the promulgation or the adoption, establishment of the speed limit on the speed limits that were already in place? Your contention, as I understand it, and I don't want to mischaracterize it, your contention is that upon the adoption of the 2017 regulation requiring a speed study, that all previously existing speed limits were null and void unless and until they were supported by a new traffic study?
So the requirement's been in place with prior versions of the procedures.
Just, if you would help me again, just answer that question. What was the effect of the adoption in 2017 of the new regulation requiring a speed study on previously adopted speed limits?
I think anything that didn't have an engineering study continued to be null and void at that point.
Continued to be. It wasn't null and void before that regulation was put in place. So the question really then is whether the regulation that was adopted operated to invalidate previously established speed limits, or was designed to apply to new speed limits or changes that were adopted from and after 2017, right?
I think speed limits that were not valid before that continued to not be valid.
Well, why would they not have been valid based on a failure to conform to a regulatory requirement if that regulatory requirement was not in effect at the time that they were established?
So previous versions have been in effect prior to that. So every previous version, all the way back to, I think, 1967, had the same requirement. So it continued to be invalid if it didn't have that before and it didn't have that.
So your citation to the 2017 regulation does not affect the imposition of the requirement for a speed study at the time that this speed limit was established? Is that what you're saying?
Right, you'd have to look to a prior version, and I do allege provisions from prior versions in my complaint. But if you're looking at the seizure that happened in 2017, or
all right, keep going.
Yeah, so if you're looking at the seizure that happened in 2018 and 2021, you would look for the definition at that point. But prior to that, the requirement existed prior to that as well. So I think, substantively, if it was void then, it was void before too, because it's been a requirement, for decades, would be my argument.
And as you know, the department has advanced the argument that that they, despite that regulatory statement, they have the discretion to establish speed limits that are not in conformity with what the speed study might suggest, or even in the absence of a speed study. How do you respond to that?
Yeah, I think I go through that in my brief. I think number one is the concession. They've conceded their binding, and I think that if you look at Chapter 85, Section 2, Chapter 90, Section 18, provision in Chapter 6C, if they make a regulation, they're bound by it. And I think I cite a Crawford case stands for that proposition. That case was about, parking regulation sign that lacks some, I think, hours. And because, the regulation said they had to put hours on it, it was unenforceable. And so I think that, it's the power to make a law isn't the power to break it. I think that's sort of what the argument is, at least the way I take it. If you have a regulation, you're bound by it, and that's...
The effect of your suggestion that the change in the limit from 60, reducing it to 55, is invalid would be to restore the prior 60-mile-an-hour speed limit. Is that correct?
So that would be effective. If they were to do that, they would have to post signs. And so in the absence of posting...
You're moving beyond...
Yeah.
Let's take it one step at a time.
Sure.
The invalidation of the change that attempted to impose a 55-mile-an-hour speed limit, the invalidation of the 55-mile-an-hour change would be to restore to effectiveness the prior 60-mile-an-hour limit, right?
I guess I'm not sure what you mean by effective, because if there's no sign, it's not effective. It has to be posted to be effective.
Well, I think we're talking about different things. You're saying, I'm saying effective, you're saying enforceable. And I understand from your reply brief that you contend that the absence of signs would mean that you couldn't be ticketed for exceeding a speed limit that wasn't posted.
Yeah, I think Chapter 90, Section 18 has language about not effective until signs are posted and only during such times that they're posted. And so neither effective nor enforceable would be my position. I do talk in my opening brief about what the move forward, how we would move forward here. And I think you also have to look at how current is the engineering study, because we do actually have an engineering study that occurred in 2005. The most recent one, I think they would have to rely on that, and I think that does not support a 60-mile-per-hour speed limit, at least from 2005 when that was actually performed.
That's a completely different question, because It seems to me that it is not necessarily the case that the department is obliged to adopt the speed limit that is supported by the speed study. They would have the regulatory policy discretion to impose a speed limit that they believe is appropriate, even if it were not the speed limit that was recommended or implied by a speed study. Would they not?
I would disagree with that. I think
Does the regulation state that both that they have to have a speed study and that the limit that they established must be the speed limit demonstrated by the study?
Correct. And so the regulatory speed limit has a three-pronged definition. It has to be supported by an engineering study, it has to have the sign regulation, it has to have the sign directed. And the procedures go through, once you do the study, you get the 85th percentile. That's the presumptive speed limit. There's discretion up to 7 miles per hour or less in exceptional circumstances, but 7 less than the 73 to 76 from the 2005 study that was done is not 60, it's not 65, it would be 70 at the minimum. And so the speed zoning procedures are very clear about the 85th sets the presumption, and then there's some discretion to come below that, but not just whatever you want.
If they do go below that, do they have to explain why?
I just don't think that's discretion. I mean, they've defined their own discretion in their regulations, and so I think they just wouldn't be permitted to do that. I think it would not be an enforceable regulatory speed limit because it would be in violation of their procedures, which define kind of the limits of their discretion based on the speed study. I see I only have a couple minutes left. I'm happy to answer any other questions. And if not, I'd rest.
Seeing none?
Okay.
We'll hear, I gather, first from the department.
Good morning, Your Honors.
From the Attorney General's Office for the Department of...
Yes, Your Honor. Samuel Fergang for the State Defendants. The
Police.
departments and the individual defendants other than Trooper Sierra.
Sorry, could you also please just pull the, thank you.
Is that better?
I think so.
Okay. Before I go into the heart of our argument, I'd like to clarify a few definitional issues and parameters about this case. The first one is that in Massachusetts, under Chapter 90, Section 17, the default speed on a divided lane highway such as Route 3 is 50 miles an hour. And a speed limit in excess of that is only allowed if there has been a special speed regulation that has been promulgated. Secondly, the 2017 standards to which Mr. Albaya referred and which we have been discussing is not a regulation. It is a guideline that follows on and is parallel to, in many respects, the federal MUTCD, and therefore it does not have the power of a regulation. Now, the SSR 7659, which is applicable here, is a regulation, and that regulation established the speed, I should correct, confirmed the 55 mile per hour speed limit on Route 3. And the reason why I say confirmed is that, as my brother laid out in his amended complaint, rather than Mr. Albaya, the process was that the prior special speed regulation 321, which was in 1966, created a 60 mile an hour speed limit. In 1974, there was federal legislation that created a mandatory national highway speed limit of 55 miles an hour, which of course applied to Massachusetts. Therefore, as of 1974, Route 3 was signposted, as were all other highways in Massachusetts, at the speed of 55 miles per hour. In 1995, in November, that federal legislation was repealed, and that led the department on an emergency basis to promulgate a new regulation to allow for continuity and validity of the existing speed signs. So what we have here is an anomaly. Normally, under Section 18, the department may create a special speed regulation to establish a new speed, but that new speed only becomes effective once the speed sign is posted. In this case, the department was trying to maintain an existing valid speed on the highway of 55 miles an hour to avoid the lacunae that would result if it didn't do so. Because if it didn't create that regulation, then automatically SSR 321 would come into effect, but the signposting on the road would not match the actual speed that was allowed.
So if that happened, which would govern?
So in that case, again, the speeds would govern, and I would like to draw your
No, which one? Because Mr. Albaya...
the speed sign would govern.
So the speed limit in theory would be 60, but as posted, it's 55, and so if someone were going, say, 57, that person could be ticketed for speeding.
That's correct, Your Honor. Unlikely, of course, the way the police work, but that would be the case. And I'd like to draw the court's attention to an additional point, and that is that in the last year, Section 18 has been amended. And in that amendment, it states, among other things, that if the department, if there's a rescission by the department of a special speed regulation, then Chapter 17 applies once the speed sign has been taken down. So in a way, what the amended statute does is affirm in writing what in practice would be the case anyway. Because under Chapter 17, under Section 17, the default speed is 50. If there's an invalid And more than that, under Chapter 18, the speed limit established by a regulation isn't valid until there's a speed sign in place. So the speed sign in place is presumptively valid unless and until it's removed and either replaced by another speed sign, by a regulation, in which case that new speed is valid, or it's not replaced, in which case the 50 mile an hour presumptive speed comes into effect. So here we have a situation where, as in the first case, there's no standing, because even if...
Let me ask you this. I want to interrupt you for a moment, please. So if Mr. El-Baya doesn't have standing, who does? Who has standing to challenge it?
Someone would have standing to challenge it if they were in fact injured. But no one, it's hard to imagine a situation...
Injured in what way? Injured in what way?
Injured by incurring a fine or that they would not otherwise incur if in fact the speed limit was invalid. And that is a very unlikely case in this scenario, because the speed limit put in place by the special speed regulation is higher than the default speed.
Right,
and because
the speed limit that was put in place was not supported by the engineering study. And so do you get to just say, well, we have discretion, and so we elected not to do that? And if that's the case, who gets to challenge it?
Well, two things there. First, I would strongly emphasize that the speed limit in place was valid, even if there may not have been a speed study, because it was in place in 1974 under federal statute, presumptively valid by federal statute, and continued to be valid because of that reason.
But those are not consistent with the signage, right?
No, they are. The speed signs are 55. They have been 55 since 1974, haven't changed. And that was the reason for the special speed regulation at issue, to maintain that continuity on the presumptive validity of the federal speed limit that had previously been established.
So who would get to challenge it? Who would have standing? In just simple terms, tell me who would have standing?
I don't know, Your Honor, because I can't see a situation where anybody would...
Nobody would have standing to me.
No, well, why would someone have standing for something where there's no harm? Why would you challenge something when there's no harm involved and where the limits of the speed...
That sounds like a circular argument to me. He's saying he's harmed
Yes.
because he's required to go a certain speed limit that is not consistent with an engineering study according to your own regulations, and you're saying, well, you don't have standing to challenge it.
Well,
You've been ticketed twice.
Well, first of all, we don't believe that it's inconsistent with the regulations, because while the regulations now, not regulations, I take it back. Again, this is not a regulation, it's a guideline. Okay. While the MUTCD guidelines and the Massachusetts cognate of those guidelines do require that a speed study be made, and in fact a speed study was made subsequently, there is not a requirement that the speed limit be at the 85th percentile mark. And I'd like to draw the court's attention to page 372 of the record, which again is an analysis of the speed studies made by MassDOT in 2005 and 2010, and that Mr. El-Baya actually adverted to in his brief and in his complaint. At that page, the junior engineer who conducted the study concluded that while they recommended, and again, recommended a general speed of 65 miles an hour, there were parts of the highway in which 55 miles an hour would be a better speed limit because of ramps and so forth. And most significantly, they reviewed an accident study which compared the accident rate on Route 3 compared to the accident rate on similar highways. At the 55 mile an hour speed limit, the accident rate was half that.
Who has standing?
Who has standing?
Yes, that's my question.
I do not believe that anyone has standing under these circumstances, Your Honor. If indeed, if there was a case where the speed limit that was established was lower than the default speed limit, and the person was ticketed under those circumstances, they would have standing if there wasn't a proper traffic study. But here...
So under these circumstances, nobody has standing?
I cannot conceive of a situation where that would be the case, because 55 miles per hour was a valid speed limit, and it's in excess of the presumptive limit of 50. So everybody...
That seems to conflate the question of standing with the merits of the question.
Well, only because there's no standing requires that there be harm. And there can be no harm if the speed limit established by the regulation is actually higher than the presumptive statutory limit. Any speed limit higher than 50 miles per hour on Route 3 is purely at the discretion of the department. The department may create a higher speed. It does not need to. It did choose to do so,
If
but
it does,
twice.
does it have to do it per any regulations?
No. No, there's no regulation requiring it to establish a higher speed limit than 50 miles an hour. And that's under, again, Chapter 90, Section 17. That is a presumptive speed limit for any unsigned posted thing, any used highway, unless they pass an SSR, a special speed regulation, with a different speed limit, which is what they did.
Thank you. We'll hear from counsel for the defendant, Sierra.
Good morning. Morning, Chief Justice, members of the panel. I'm Joseph Donlin. I'm here on behalf of Michael Sierra. Michael Sierra is a state trooper, and he is the law enforcement officer who cited the plaintiff on Route 3 in Burlington. When he being Trooper Sierra, effected the motor vehicle stop, he had a reasonable suspicion to do so. He had a personal observation of the plaintiff traveling in excess of the speed limit. He observed him at 72 in a 55. That allowed him to stop him. Upon his further investigation, that level accelerated or advanced, if you will, to probable cause, and he was allowed to issue him a traffic citation. And as far as the analysis goes, that should end the case against Trooper Sierra, because he acted based on reasonable suspicion, and then, again, the issuance was on probable cause that the violator was exceeding the speed limit. Now, there's claims that there's a violation of privacy here. The actions of the plaintiff were undertaken in public, and when we act in public, we shed the cloak of privacy that we all as citizens have, and there's no entitlement to speed. So the claim of a violation of his rights to privacy under 214 also fail. There's a claim with respect to threats.
Let me just interrupt you for 1 second, Attorney Donlin. So anytime it happens in public, no claim for right to privacy. Is that what I hear you say?
Not any time, but under these circumstances, because what we're going to do is, we're going to look at then, well, what's the invasion of privacy? It's substantial, is it serious? And a 10-minute traffic stop on the side of the road doesn't meet that standard either.
I'm a little puzzled because I had thought that the question of Trooper Sierra's potential civil liability was resolved on the basis of his immunity in the performance of his official duties.
It does. He's entitled to qualified immunity, without a doubt, and it's because that he hasn't violated a recognized right of the plaintiff.
So it has less to do with public versus private privacy or the merits of the underlying reasonable suspicion or probable cause. I mean, I understand that if there was absolutely no basis, he would lose his qualified immunity, but the question at the center of Sierra's position in this case is qualified immunity under state statute.
Yes, it is. It's absolutely, he's qualified, and my analysis is attempting to show that, well, there's no violation of a protected right. So therefore, he's entitled to qualified immunity because the plaintiff hasn't even met that threshold. And so that goes through with respect to the threats, intimidation, and coercion under the Mass Torts Claim Act, where we've got the case of Smigliano, where any reasonable motor vehicle operator understands that when the blue lights go on behind you, you pull over and you deal with a traffic citation. And it's the reasonable person standard that applies, not the subjective standard that the plaintiff is suggesting applies. And again, I am I point to the fact that the plaintiff's been through it before. He understands what happens at a traffic stop. You pull over, you produce your license, and you go on your way. And here, a use of lights, use of the siren, and a 10-minute delay on the side of the road in nowhere comes near to violating any of these rights. And the suggestion that the trooper is required somehow to go behind the speed limit, the speed sign, and see if there was a traffic engineering study or somehow validate that is also without any support or any authority. And we suggest that that's another reason that qualified immunity applies. And if the court below inarticulately set out why qualified immunity applied, you obviously can apply what the standard would be. It's that the fact is that there is no deprivation of a recognized right by Trooper Sierra, and that's why he's entitled to qualified immunity. Thank you very much.
Nothing further. I see no further questions from the panel. The case is submitted.
Thank you.
We move to the sixth and final case on our list for argument today, case number 2023-P645. This is a case involving termination of parental rights. The case is impounded. I'll just remind counsel that regardless of who else is in the courtroom, we are streaming to our YouTube channel, and the video of this and audio of this argument will be available for public viewing. So we're refrained from references to the parties by name, mother, father, child, etc.
Good afternoon, Your Honors.
It's hard to tell, but good afternoon, Mr. Yanoff.
My name is Warren Yanoff. I represent the father of the child L in this case. The trial court erred in terminating my client's parental rights, and this started because the department really did not only offer him appropriate services, but from the time of removal, their basis was erroneous. This was a child who was born in 2020. Custody was given to my client. He was living at the time with his mother. There were no issues, there were no incidents. What had occurred was an alleged incident of domestic violence between mother and father. However, when you look at the police report and you listen to the reports of mother and father, he was not present. The cause for removal didn't exist in terms of him. And so the removal itself should never have occurred. Once that occurred, the problem is he was 18 years old at the time. When the child was born, he was 17. But again, there had been no issues. The social worker testifies that there were no programs that in the Commonwealth to help a young father learn to parent the child. Notwithstanding that, there were no issues in that arrangement. The department says, and the judge finds, that he didn't comply with services. Well, some of the services were unavailable. He couldn't do the parenting partner program because they changed the goal to adoption, and that had to be, to do that program, you had to have a goal of reunification.
Were the domestic violence services available?
There was a referral to the, I believe, the intimate partner program, but that was going to take a long time, according to. But he had already taken.
Domestic violence services available.
In the record, it doesn't appear. He had indicated he had signed up for some right during about 3 months or so before trial. He had taken domestic violence or anger management, I should say, while he was in DYS, but during the time that he had the child, there was an acknowledgement in the foster care reviews that he wasn't doing all the services, wasn't doing that, but there was no issue in the parenting. There was no, the domestic violence.
Was he resistant to taking domestic violence courses? I ask about domestic violence because that seems to be a central issue in the relationship between father and mother. And so I'm asking you specifically, was he resistant to doing domestic violence classes?
I would say, I wouldn't say he was resistant. I think he felt that he had taken courses, and the ones that they had offered were not available during this time period, being during the pandemic and things of that nature. He started one, as I read the record, and was in that process. So he wasn't really resistant. But I think we have to deal with this child never witnessed any of the domestic violence between mother and father, if there were any. And again, his testimony, mother's, is that it was not physical, it was more anger, yelling, and things of that nature, not to that. They weren't living together. There was nothing, the social worker said that he would...
The mom suffered some serious injuries, it appears, arguably at the hands of father. She took out a restraining order against him, right?
She filed it and then... Mother's credibility, with all due respect, with regard to that, is not necessarily that credible. But when you look at the incident on her, he was not there. That's really the real issue, is we start this and then they don't have the right programs. And then the judge, I think, compounds it by saying, well, we find by a fair preponderance of the evidence, not clear and convincing, the judge says, well, we think, or the judge thinks that he's not going to improve. This is an 18-year-old individual who the Commonwealth acknowledges doesn't have the services to help him, but yet when they were parenting, when he was parenting the child, there was no issues.
When he was parenting the child, was he doing that with the help of his parents?
Yes, and there was no reason that...
And did his parents move and he didn't even know where they lived?
But at that point, they had already removed the child. What I'm saying is that the department...
But I think Justice Desmond's question is, what is the evidence on which the judge might have relied to reach a conclusion that the father was capable of parenting the child without the assistance of his parents?
To the extent... I think it's a twofold question. I think we don't know, and you can't necessarily infer that he couldn't parent. There's no evidence that says...
No, the judge didn't use that as the basis to conclude that he couldn't, but I'm simply asking how it might be applied, as you suggest, to negate the conclusion that he couldn't. And the judge relied on different criteria to conclude that he was not capable of parenting the child.
I think the judge also relied inappropriately on the fact that he had a juvenile record. And I think that's very clear according to the statute.
Not a record, but that there were charges.
There were charges.
And that there was conduct that gave rise to those charges.
And that's not allowed according to the statute. The fact
So if he engages in criminal conduct as a juvenile that's not charged, that can be used to bear on his fitness, but if it results in charges, then all of a sudden it's out of bounds?
Correct.
Even though they're permitted to look at past behavior to help predict future behavior.
But in this case, we have somebody who's that young who didn't, I think you still have to put it into that context of when he was having custody of his child, there were no issues. The foster care review even said DCF didn't do what it was. The judge based its termination, and I know if you allow me just
finish your sentence.
Thank you. On bonding, didn't talk really about best interest of this child. Only said that the pre-adoptive parents were good people. I'm not questioning that. That's against.
Thank you, Mr. Yano.
Thank you very much. I appreciate it.
Have your brief. We'll hear from counsel for the mother.
Good afternoon. May it please the court, my name is Alan Campbell and I represent the mother in this case. In this appeal, mother is seeking vacation of the termination decree, or in the alternative, an increase of visitation to 2 annual visits a year. And the primary issue I'd like to talk about is that the judge erred by taking judicial notice of the findings of fact from the prior termination decree, or the prior termination trial. And my support for this is care and protection of Zeta, which expressly says the findings from a different case are not allowed in another case. I believe the language is barring issue preclusion or a statute allowing for their admission, they're not admissible. There's no statute in this case that allows them, and there's no question of issue preclusion because the issues at the first trial are completely different from the issues at the second trial.
There is one difference between, well, there are probably more than one, but one difference between the Zeta case and this case is that in the Zeta case, the judge was relying on the judge's own recollections from the earlier cases as opposed to relying on record evidence from the earlier case. Is that a distinction without a difference?
It is, because of the language that I've just cited. It's discussing in the same section where it says that the judge was relying on it. It goes through, in essence, I think the SJC was saying, even if these findings were written down, even if rather than relying on the memory, it was based on prior findings that had been written down, they still wouldn't have been admissible. And
doesn't Darla say that they can be used in some instances, though?
Darla does, and as I mentioned in my brief, Zeta came 7 years after Darla and is an SJC versus an appeals court case. And
what are you saying?
I'm
not
saying,
as good as them?
Not
All
at
right,
all.
we know that.
I'm not saying they're right, but they do win out. They do trump out or win out. So I think.
Well, yeah, to the extent that they abrogate one of our holdings, or that they decide the same question on the same in a different way, their decision controls. But I think it suggests also the possibility that Judge Hirschfang is not very far off base when she suggests that Czar is distinguishable from the circumstances of this case,
Zeta,
or from Darla.
But the language that I'm relying on in Zeta is directly opposite Darla. It's not in this situation you can do that. The language says, barring issue preclusion or a statute allowing further admissions, finding from one proceeding are not admissible in another proceeding. That's a axiomatic statement of law that is contrary to Darla. So that's why I said it implicitly overruled it. They didn't say we're overruling it. But you cannot, there's no way to reconcile those two pieces of law. Darla says they're admissible, Zeta says they're not. There's not nuance in that. Those are straight up contradictions. And without conceding that they are admissible, but even if Darla is good law, they still shouldn't have been admitted because they related to different children. The father was different. The findings were still under appeal at the time they were entered. And there are several cases, which I cite in my briefs, that says in those situations, and this is even when it's a care and protection, rather a termination trial following a care and protection trial for the same children, even in those situations, I cite numerous cases that say the better practice is not to admit them. They really had no place in this case. And DCF mentions in its brief or claims in the brief that I didn't cite any specific findings that weren't based on the evidence at the second trial. I would disagree. There are, I believe it's 11 findings. It's prior findings 17, and I have these are my brief, but 17, 19, 40, 51 to 56 are all based on evidence that was not admitted at the second trial. It's either based on trial testimony of witnesses who didn't call, or in some instances, what the prior judge saw on the Zoom trial, which isn't in the record. It was things in the background and such, and mother's conduct during the trial, which isn't part of the record.
Does it matter that the judge indicated that she was going to look back just up until the time when this child was born, but was only applying the facts from there going forward to this?
It does not, because she did First judge was a she, the second one was a he. I'll apologize in advance if I make a mistake. The second judge actually said, I'm going to primarily consider, not I'm only going to consider, I'm going to
She's a she.
The second judge was the he. This is the one I'm referring to. I thought, well, whatever. The second judge didn't say I'm only going to consider from the birth. They said I'm primarily going to consider from the time mother was pregnant. So mother was pregnant in, I believe, August of 2019. The second trial is June of 2021. So we have 22 months of this case that the judge is going to primarily consider. And when the judge starts their summary, in the conclusion, they go through the findings, which unfortunately weren't numbered. It made it a little difficult to write. But when they, in the section between the facts and the conclusions, where they have a summary and they discuss the case, they say on June 21st, the judge found mother was unfit. These are the reasons. And then, in essence, goes on to say, and things haven't changed since there, which sounds a lot like a review and redetermination in the same case, not a termination trial in a new case involving a new child. But a parent isn't actually found, as this court's aware, a judge doesn't actually find a parent unfit. They find a parent unfit to care for a particular child. These are totally different children with totally different needs. And the judge, I mean, it's, to my mind, hopefully you agree with me, the judge starts from the premise, mother is unfit, and now I'm going to, and this is some of the judge's actual language, look at her progress. That is a fatal flaw.
So is it your position that the record does not support a finding of unfitness for mom? Is that your position?
My position is that it was a legal error requiring reversal to admit these findings. But yes, I also do believe that if you look at all of the evidence in the case, even including the prior findings, that there isn't a sufficient nexus between mother's conduct and risk of harm to the child. The mother was never given an opportunity to parent this child.
Mother's conduct and best interest of the child.
Well, I don't even think you should be getting to best interest, because the first question is whether mother is fit, and if she's fit, that's the end of it. I believe she actually is fit, and that there isn't a nexus. There is evidence of some things that mother did that weren't great. She did none of those while in a parenting role for this child. She was appropriate during all visits. She did work on some domestic violence things. She had gotten a restraining order against father. They were no longer a couple at the time of trial.
Thank you, Mr. Campbell.
And my time is up.
The department?
Yes, Your Honor. May it please the court. My name is Aaron McCriss on behalf of the Department of Children and Families. In this case, there was overwhelming evidence before the trial court of domestic violence, of substance abuse, and other instabilities that undermined both father's and mother's parental fitness. And there's no basis on appeal to disturb the trial court's evaluation of that evidence.
Well, let's set that aside for the moment and examine some of the particular claims of error, starting with the one that we were most recently discussing, the question of the use of findings and or evidence from a prior proceeding in support of the decision in this case.
Yes, Your Honor. As the court pointed out during opposing counsel's presentation, this case is essentially on all fours with Darla. There's really no question about that.
But what about Zita?
Well, the question as to whether Zita overruled Darla, the answer is no.
Well, let's set aside for the moment the question of what Darla said and look at what Zita has to say about what the judge did in this case. Does what the judge did in this case comport with the holding of Zita?
Yes, Your Honor, and I'll make 2 points in response to that question. First, Zita didn't purport to affect any change in the law. It was addressing a very narrow factual situation that just isn't present here. And that is, the same judge was presiding over two separate sets of proceedings and essentially just relying on what that judge had privately learned during the prior proceedings. I forget the exact language from the opinion, but it said something to the effect of the difficulty of this case is the commingling of the facts between the first proceedings and the second. Some of that was in evidence in the later proceedings, some of it wasn't. But Your Honors, to put this in context, and I think to understand what's really going on with Zita, and this is the second point that I alluded to, it didn't overrule adoption of Frederick. Adoption of Frederick is another Supreme Judicial Court opinion that precedes all the other cases that we're citing. Darla was only applying adoption of Frederick, which said itself it is proper to consider findings and evidence from earlier proceedings in later proceedings. Now, what that court did change, what Frederick did change, was whether those findings have preclusive effect. And this is explained in adoption of Isabel, one of the primary authorities on which Mother relies. Essentially, Frederick says those findings are no longer have preclusive effect, but as long as the test for issue preclusion is satisfied, that they're material and relevant, and that there was an adequate incentive to litigate, then it's appropriate to consider them. And Zita is couched in those terms. It says absent issue preclusion, and then goes on to cite the rule that Mother quotes.
And then is the distinction between the children involved in each petition, does that go to the ultimate findings and rather than to the subsidiary findings that supported the conclusion of unfitness?
Your Honor, just to make sure I'm hearing your question correctly, as I understand it, you're asking, is the difference between the children in the first proceeding and the second proceeding?
In terms of preclusive effect and in terms of the appropriate weight to be applied, Zita includes a fairly explicit and clear statement that one of the reasons why even findings from a prior proceeding are not appropriate for use in a subsequent proceeding is that the proceedings involve different children. And the fitness to or capacity to parent a child is dependent on the circumstances of that child, as you well know.
In broad strokes, Your Honor, that's correct. And that was one fact that troubled the court in Zita. Here, that concern isn't present. And the reason that's not present is the manner in which the trial court relied on the prior findings. The trial court said expressly it was limiting its reliance on the prior findings, all of which, again, are established by direct evidence, to Mother's progress and her history with DCF, and that's it. Those are general facts that are agnostic to which child is at issue. And because the trial court was relying on the prior findings, again, which were supported by the direct evidence, that concern in Zita isn't present. And I'll just highlight, for clarity in the record, there were multiple social workers that testified at these proceedings below. One of those social workers had worked with Mother from 2019 all the way through October of 2021, which overlaps with the entirety of her pregnancy and the time period at issue, the time period for which the trial court was relying on findings from the earlier proceedings. Your Honor, I'll now turn to Mother's counsel's suggestion during the presentation that just occurred that Mother's issues with alcohol never occurred in the presence of children. The law on nexus doesn't require that there's any direct injury to the child or that problems with substance abuse are exhibited in the presence of the child. The question is just whether those issues undermine a parent's fitness or their ability to parent. Here, there was ample evidence in the record that Mother had substance abuse problems, primarily alcohol, that undermined her ability to parent, including that she was hospitalized for alcohol poisoning at one point and became so combative during that incident that she needed to be sedated, both by the paramedics at the scene when she was picked up and again later at the hospital. I'll turn now to some of Father's arguments, starting with the argument about the delinquency charges. Setting aside how the statute applies, this was a waived objection. This court addressed almost exactly this same circumstance a couple of months ago in a case called Adoption of Fabio, where a father's delinquency records were admitted without objection and then argued on appeal that they were prohibited by this very statute. And this court rightly concluded in that case that that objection was waived and not preserved for appeal. The same is true here. The only evidence that the trial court relied upon in connection with Father's delinquency record was the North Adams police records. And those records were admitted without objection, and that should be the end of this issue.
Can I ask you another question about the father's record? The judge included in the rulings something about, and I'm going to get the words wrong, but the father had an adult record. My review, which is never really reliable, of the record seems to support that. What are we to make of that? First of all, is that right? And second, if so, what do we do with that finding, both It's easy to say, well, and I'm sure you will, if you disregard it, there's still enough there, but it also indicates sort of a carelessness with the record that I wonder what you say about.
Yes, Your Honor. I think that statement in the opinion would be more troubling if it referred to convictions or something more specific. I think in context, what the trial court clearly had in mind was the regular police involvement in father's life, as is discussed in the briefing extensively. The police were called for reports of domestic disturbances 4 times in a period of 6 months. In one of those incidents, mother obtained an abuse prevention order against father. That, I think, is what the trial court had in mind when it referred to his adult record. And beyond that, again, to emphasize the point that you just made, even setting that aside, there was ample evidence in this case of domestic violence and other issues undermining father's parental fitness. I'll briefly address a couple of points made during father's argument. One is that father didn't receive adequate services by DCF. DCF provided plenty services to father, and he didn't meaningfully engage with them. Just as some examples, they referred him to parenting classes. Father did not complete a 24/7 dads program and other services in that regard. There was some minimal engagement, but not complete engagement. He did not complete an abuse prevention program. During his own testimony at trial, he was very resistant to the basic notion that there even was a domestic violence problem in his relationship with mother. He was referred to psychological assessment. He refused that. It was requested that he submit to a drug screen. He refused that, and that all appears at Appendix 33 and 38 to 39 of the record. And finally, I'll address the mention that Father's counsel made about the November 2020 incident where mother sustained a fracture to her orbital socket. So I just want to clarify, because there seems to be some confusion about the record. There is a suggestion in one of the police reports that father's sister may have been the one who punched mother in the face. It's completely beside the point. There was overwhelming evidence, setting aside that police report, that father was engaged in acts of domestic violence against mother. But more importantly, even if it was his sister who was the one who punched her in the face, father was apparently leveraging threats from his family members against mother. I'll just briefly quote an affidavit that she submitted when she obtained the abuse prevention order. And this is her talking about father. In the past, he has smacked me across the face, pushed me into things, choked me once, threatens me with his mother, dad, and sister. Sister broke my eye socket in November 2019. I just want him and his family to stay away. I'm afraid.
Right, that's on page 421 of the volume 2 of the exhibit appendix.
Correct, Your Honor. There was overwhelming evidence that mother and the child would be in this environment where mother was living with father and his parents that was plagued with domestic violence and consistent incidences of police becoming involved. And when you add all of that together, there's no question that there was adequate evidence in the record to support the finding that mother and father were unfit.
Thank you. Finally, counsel for the child.
Good afternoon, Mr. Chief Justice. Good afternoon, members of the panel. Eric Beal on behalf of the child. The court's judgment and orders finding both mother and father unfit and the decrees terminating parental rights should be affirmed. There was, I would submit, overwhelming evidence of unfitness for both parents, and principally, as Justice Desmond asked about earlier in this argument, the uncontested evidence of domestic violence that spanned a period of several months following the birth of the child through removal. And specifically it related to one of the incidents in which mother sustained an eye injury. When the court investigator interviewed the mother had counsel present, mother admitted that she may have said that the father was the one who hit her and caused the injury. And I would submit that that's conclusive and supports the court's findings on that issue. With respect to the questions related to father's participation in the service plan, there was testimony from the father and social workers that he refused domestic violence services. Father testified he didn't need any services. And he testified that the police reports regarding domestic violence were false. He testified that the police reports regarding his intoxication as a minor were false reports. And he, in fact, at some point refused to communicate with DCF on the rationale that last time they communicated with DCF, the child was removed. So he wasn't going to communicate with the department anymore. And with respect to mother, again, there's the uncontested evidence of domestic violence as to unfitness, but also mother's substance abuse diagnosis, which is uncontested, and mother simply did not address those issues. And father essentially said, well, that's mother. If she wants to drink, she's an adult, she can drink. Mother did participate in a domestic violence program, but did not prepare a safety plan, and throughout trial denied that there was domestic violence occurring, and that, as the court found, undermined mother's credibility with respect to the domestic violence issue.
What do you say to mom's housing stability?
Yes, Your Honor. The significance, I would argue, is the housing was not the lack of a lease necessarily, or even that the nature of this physical space, let me say, but that the housing was owned and controlled by the father's parents. It was a duplex. The other unit was occupied by father's sister, who mother had said in her affidavit was an abuser. And so that is, as far as having safe housing for a toddler, I would submit that that was the principal issue. Mother had also stated that father's family had chased her down the street at some point, and that she had produced a taser to defend herself. So these are the people who own the housing, control it, and her neighbors, and father is living across the street. So that, I think that's the principal issue with housing on that issue. I would, regarding the admission of the 2021 findings, there was a case, and I cited in my brief, from 2017, which post-dates both Zita and Darla. It's adoption of Zara, and that's 91 Mass App Court 1107. It was an unpublished decision. I attached a copy in the appendix to my brief. If there are no further questions, I would rest on my brief at this point and ask that the underlying orders and decrees be affirmed.
Seeing no questions, thank you. Thank you all for your argument. The case is submitted. That concludes our session for today. We are adjourned.
Thank you.